inquiry pre-meeting, just a few minutes late. Welcome. Can everybody hear and see me? I know you've been checking with David there, but is everybody hearing me? I'm not seeing, just put the microphone, the cameras on just for key participants just now. Thank you. So welcome to the meeting in relation to the SP Transmission PLC Glenmuckloch to Glenglass Reinforcement Project Compulsory Purchase Order 2024. My name is Elspeth Cook. I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, DPEA, and I've been appointed by Scottish ministers to consider the proposed order and the objections to it, to hold an inquiry if necessary, and to submit a report to Scottish ministers, making findings in fact and recommending whether or not the order should be made. This is a virtual meeting and is being broadcast live, and as such will be stored as part of the DPA website archives and will be capable of repeat viewing. By participating in the virtual inquiry, virtual meeting, you're consented to being filmed. You're also consented to the use and the storage of the images and sound recordings for and any images or information pertaining to you contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. Further detail on the DPA privacy policy can be found on our website. As you know, David Spears is here today. He's arranged the meeting. He'll be monitoring the event in the background and hopefully step in if we've got any technical difficulties. If you intend to speak today, it's helpful to keep your camera turned on and to use the hand waving tool if you wish to attract my attention. I think most people know how to use that part of the Teams meeting system. Of course, someone at some point may to mute or unmute their microphone at some point today, so feel free to step in at any time if that happens. It's a common problem. So I'm joined today by representatives of the people or the organisations that have submitted objections to the order, and also the representatives of the acquiring authority who are promoting the order. So it's quite important to introduce each other, make sure everybody's aware of who's attending on behalf of which objection. But I'll start with the acquiring authority first and ask the lead participant to introduce themselves and those that are attending with you today. And we'll start with that. I think Mr. Armstrong, possibly, is it?
Yes, ma'am. Good morning, ma'am. My name is Douglas Armstrong. I'm a member of the Faculty of Advocates, King's Counsel, and I'm instructed by Magdalena McLean, partner in Shepherd and Weatherburn, who is sitting to my right. Also in the front row here on my left is Zoe Rocks and Mark Peebles, property and planning solicitors with SP Energy Network. And I'm also assisted by Nicholas McAndrew, advocate, who's also a member of the Faculty of Advocates. There are a number of other people who are present today, and Ma'am, I understand you've got a list of the various people.
Yes, I do, thank you.
Present today. In addition to that list, there is also Andy Hutchison, environmental planner, who should be added to that list.
Yep, I've done that, thank you. There were 6 letters of objection submitted regarding the order. These letters have been given a number 1 to 6 for no other reason, I think, than the date they arrived. Representatives from 5 of those letters are attending today. So can the lead person for each objection letter introduce themselves and any others attending with them? I'll take them just in the numerical order for ease. So the objection 1 is attributed to Buccleuch Estates Limited and Glenmuckloch Restoration Limited and Glenmuckloch Minerals Limited.
Thank you, ma'am. My name is Chris Devlin. I'm a partner with the law firm Anderson Strathern. And as you pointed out, I'm representing the Buccleuch Estates Limited, Glenmuckloch Restoration Limited, and Glenmuckloch Minerals Limited. I'm attending this pre-inquiry meeting just on my own. I don't have any other parties with me.
Thank you. Objection 2 was the various organisations called the Woodcock Entities, and that's coming, I think, from Tyrconnell.
Yes, thank you, Elspeth. It's Neil Stringer and Paul Forster-Smith representing the various Woodcock entities. You want to add at the time?
Thank you. Objection 3 was Drumbuie Renewables Limited and the Walkers.
Good morning, ma'am. My name is Graham Dunlop. I'm a member of the Faculty of Advocates, and I represent both Drumbuie Renewables Limited and also Community Wind Power. I suspect it just makes sense for me to deal with that. They may be lower in your numbered list, but deal with them just at the same time.
Yeah.
So I represent them jointly. They have joint interests, and today I'm joined by my instructing agent, who's Miss Keir Donnelly, and Mr. Stuart Walker, who's a director of Drumbuie Renewables, and also Miss Kirsty Kelshaw, who's legal counsel for Community Wind Power.
Right, thank you. Yes, the Sancra Community Wind Farm comes in as objection 5. Objection 4 is the Kirkpatrick interests, and they are not represented here today. And then that leaves us at objection 6, the Sandy Now Wind Farm.
Good morning, everybody. Can you hear me okay?
Yes, thank you.
Hello. Hi. My name is Lynette Purvis, and I'm the head of legal for the UK for ERG. So I am here representing ERG UK Holding Limited and Sandy Now Wind Farm Limited. And I am joined today by Darrell Tiglau and Fraser Campbell.
Right, thank you. Is there anybody else attending today that we've missed that isn't already represented there? I think we've caught everybody. Thank you. I think that's us. Receipt. Item 2 on the agenda is just a summary.
Sorry,
Oh, sorry.
Sorry. Mike Woodcock, who obviously we represent one of our owners, is trying to get into the meeting, so he's just calling me now. So we're having difficulties with him, but I'll get him in. So I'll just see. I'll try to sort that out. Okay. But you might be joining.
Right, I'll look for him attending. It's okay if I keep going. I've just got a bit of housekeeping to do, and hopefully he'll be joined before we actually get to the matters that directly involve him. So the purpose of the meeting is really just to summarise what's happening here today. My remit and the scope of the inquiry is prescribed by the legislation. That's the 3 things in the heading to the agenda, which is the Acquisition of Land Authorisation Procedure Scotland Act 1947, the Electricity Act 1989, and the Compulsory Purchase by Public Authorities Inquiry Procedures Rules 1998. So the purpose of the meeting is to discuss the procedural arrangements for the inquiry. The meeting doesn't form part of the inquiry itself. So there's no discussion on the merits or otherwise of the order or the individual cases put forward by the objectors. However, it will be necessary to discuss the nature of the objections, in particular those parts that may need to be considered within the inquiry process, primarily because any objection that relates exclusively to compensation matters must be disregarded by the inquiry, because those matters would be considered and determined by the Lands Tribunal if the order is confirmed and agreement on compensation can't be reached between the parties. I'm going to be keeping a note of the meeting as we go through our discussions today, with a view to preparing a formal note of the meeting, and I'll circulate that as soon as possible, and it will function as a procedure notice setting out the next steps required of the inquiry participants. I'm hoping we can make good progress through the agenda and that we'll be finished by lunchtime. It might be that it's prudent to take a break after about an hour and a quarter perhaps. We'll see how the agenda progresses and we can make that decision if we need to just take a break from the screens. It's always beneficial when you're dealing with online meetings. Did anybody have a question about the purpose of today's meeting? Not seeing anybody put their hands up, that's fine. Oh, Paul Forster-Smith.
Yes, I've just been speaking to Dr. Woodcock there. He's just asked me if I could formally record his objecting to this proceeding because he cannot get into the meeting. Okay? So he's trying there, so I'm just raising that. And in the meantime, I'll try and make sure he's on. Okay, but he would like me to formally the principal objector cannot get into the meeting despite following all the instructions he's been given. Right.
Thank you. Is David Spears listening? Is there anything you can help David with that? Is there a means to create a new link and send it direct to Dr. Woodcock?
So I can see what I can do there. If you can email his contact, I can give him a call and see what we can sort.
Yeah.
Excuse me, sorry.
Somebody able to do that or send it direct through to David? I think you've got David Spears' email address perhaps in your records. Is that possible? Could give that a go. Sort out. Not the purpose to exclude anybody, but obviously technology being what it is, sometimes these things happen, and it can be at our end, but it also can be the person's own technology, and we just can't tell easily. So we'll let that run for another few minutes, because I'm actually going to ask move on to item 3, which is really just to get us an update on the objections primarily from the acquiring authorities' point of view, just to see where we are and see what progress has been made with negotiations in the interim period since these letters were first submitted. So perhaps ask the authority first just to summarise where they think they are with the various negotiations in terms of acquiring land or rights voluntarily.
Thank you, ma'am. Just perhaps in relation to Dr. Woodcock, before we go any further, because I'm obviously conscious that if he's not represented here, then there could be an issue. Can I just confirm whether it might be helpful to confirm whether Turk and Connell are acting for Dr. Woodcock, and so there is actually a representative of Dr. Woodcock present at the proceedings? Because I think if that is the case, then we can obviously go on, but I'd be concerned, obviously, if there's an objector who's not represented here today.
Yep.
And is missing out in any aspect of the pre-inquiry meeting.
Mr. Stringer?
That's understood.
There's right, Michael Woodcock just disappearing as asking to be admitted. So I think we might have addressed that. Is David admitting him? Yeah.
Somebody needs to let us in.
Yeah. So Michael Woodcock's here. Dr. Woodcock, can you hear and see the proceedings now?
Hello?
Dr. Woodcock, can you see and hear the people that are participating in the meeting today?
I can for the first time right now.
Okay. So just to let you know, we've just reached item 3 on the agenda. We've been discussing just the purpose of the meeting. I don't think you've missed too much. We've just been talking about what we're going to do today, and we're about to look at asking the authority to give us an update on where they are with the objections. So we haven't discussed your objection or any matters directly relating to you at this point. So back to Mr. Armstrong. Sorry.
So there's nothing I've missed in the last 20 minutes.
Really just some procedural stuff about how we're going to conduct our business today. The hope that we'll be finished by lunchtime. We might take a break if it's going on a bit long. And a couple of bits of housekeeping, turning off cameras and microphones if you're not needing to speak, so that it doesn't disturb the flow of the meeting. And that we're not discussing the merits of the case at all today, although we might discuss the nature of some of the objections so that we can work out whether or not they need to move forward into the inquiry process. And we're just really about to start that business now. Okay.
Thank you.
That's great. Thank you. Right. So, Mr. Armstrong.
Ma'am, if I can just go through the various objections and give you a brief update. Perhaps starting first of all with Agnes Kirkpatrick, who's obviously not represented today. It's just to inform you that we are optimistic that an agreement is likely to be forthcoming and that that objection will be withdrawn in the near future.
Thank you.
In relation to the Walker entities, and if I can call them that, SPT have engaged with these parties, but they're still awaiting a detailed response. The acquiring authority remain willing to continue to engage in discussions with them. And in relation to all the other objectors, the inquiry authority has engaged in voluntary discussions with these parties, and discussions are ongoing.
Right, so do each of the objectors want to respond on that summary? Do they want to kind of give their own impression on that? Starting again in numerical order, starting with objection 1 and the Buccleuch Estates group.
Thank you, ma'am. I don't really have very much to add to that. The client has informed me that discussions are ongoing with the acquiring authority, and for as long as those discussions remain ongoing, the objection that has been lodged already will be maintained unless a conclusion in terms of a voluntary agreement can actually be reached.
Objection 2 is the Woodcock entities.
Similar, maintain the objection. I mean, we've had correspondence, but no actual discussions as yet. But we are trying to fix a meeting up for the weekend commencing the 8th of July. So I think that if we get a meeting, that'll be, they will be discussing. But at the moment, it's just people just put their views, and there's been no there's no agreement or really discourse as yet. But hopefully, following the meetings to be agreed.
Could I please add to that? I mean, there have been attempted discussions over the last 2 years. They've been totally unsuccessful because each time that we have engaged with Scottish Power, they have never done what they've agreed to do. And it is only with the advent of this inquiry that their solicitors have now suggested that we engage with them.
Thank you. Objection 3 is the Drumui and Walkers.
Yes, thank you, ma'am. I suppose dealing with community wind power first. The first contact from Scottish Power was in March this year, and the first meeting took place on the 24th of May. Since then, community wind power have been assessing some of the impacts. I don't wish to be negative, but we think it's unlikely that we're going to be able to come to a solution. But I suppose just what I wanted to highlight is that the discussions are a very embryonic stage, because the first contact was only made a couple of months ago with community wind power. Moving on to Drumbuie renewables, there's been, I suppose, more detailed discussion than there has been with community wind power. There had been a head of terms prepared, but unfortunately they don't address any of the issues, particularly in terms of underground cabling or alternative routes. They just really deal with the issue of compensation. So again, without wishing to sound negative, I'm not at the moment confident that any discussions that take place between now and the inquiry or hearing sessions will be fruitful.
Okay, thank you. And then objection 6, the Sandy Now wind farm.
Lynette speaking. So correspondence and discussions are ongoing between ourselves and the acquiring authority, but the objections of ours are to be maintained in the meantime unless and until a voluntary agreement can be reached.
That's fine, thank you. I wanted to just double check with SPT, with Mr. Armstrong, as whether have we actually resolved that all the interested parties have now been properly engaged? There's reference in various letters, I think within objection 1, that the Clue estate indicated that they didn't own some of the land that I think was being attributed to them. And also I think within objection 2, within the Woodcock issues, that there was reference to tenants and other parties that might have been overlooked in some way. Are we able to confirm that all those matters are now covered? I think you dealt with the Kirkpatrick issues a few weeks ago.
Yes, ma'am, that is correct. It is the acquiring authority's position that on the evidence before it, all the owners and occupiers of the order land have been identified and notified.
Can I say that is incorrect? We are owners of land affected who have not been notified. And I know for a fact that the acquiring authority have notified people who don't own them.
Are we able to identify those pockets of land so that that matter could be resolved? It's a bit unfair to the authority to kind of leave it just as, you know, there's some land. I don't think we're not going to be able to sort that out.
I'm sure I could fancy the answer, but one of the problems is it's very difficult to engage with Scottish Power. They're only interested in their own position.
Right. Mr. Stringer or Mr. Forster-Smith?
I'll have to speak to the class. I can solve that with Scottish Power and their agents, okay, following this meeting. Okay, let's move on and we can discuss that after. Okay.
Right, okay.
Yeah, that's all.
And I'm just wanting to check, I think I'm correct, so just maybe a thumbs up here. Obviously, each letter of objection comes from a group of companies or entities, and they're all being represented in a certain way. And I get the impression that that's not changing, that these objections are coming forward with single point of representation, and that doesn't seem to have altered, perhaps with the exception that Mr. Dunlop is now picking up the interests of 2 of those parties. Would that be correct? So there's no real change to the way people are being represented. I'm not seeing anybody putting their hands up or saying anything, so that's fine. So I think, does anybody have anything else they wish to add regarding just where we are with the objections and the status of anything, the objection itself or the representatives for them? No, okay, that's fine. So item 4 on the agenda is just really an update on the Section 37 decision, and whether that's made any difference to the order or any other implications arising from the receipt of the relevant permissions. Mr. Armstrong, sorry.
As you correctly point out, the Scottish Government issued a letter on the 23rd of April 2024, which contains the Scottish Minister's decision to grant Section 37 consent and a direction that planning permission is deemed to be granted. That letter obviously sets out various conclusions of the Scottish ministers on issues raised by objectors in the proceedings before you, ma'am. The decision obviously has implications in relation to a number of topics that you have identified in Annex A to the agenda for today. Obviously, one that comes up straight away, I suppose, is the issue of prematurity, where a number of objectors had taken a point in relation to that. I'm sure we'll go on to discuss the implications of the Section 37 decision when we come on to look at the various topics. But obviously it's relevant to have regard to the acceptance by the Scottish ministers of the position in relation to the EIA report and the impacts on the environment and the design process and routing of the proposal. But I'm sure we'll come back to that in, I think, item 6 or item 7.
And Mr. Dunlop, you've got your hand up on this.
Yes, thank you, ma'am. It was just simply to identify that my client, and I say my clients, both Drumbury Renewables Limited and Community Wind Power, they've taken legal advice from both me and my instructing agents, and they're actively considering whether or not to challenge the decision. So whilst I take on board the point made by Mr. Armstrong, we're still within the time limits, obviously, for a judicial review. Unfortunately, I'm not in a position to say whether or not that will take place today. I simply wanted to highlight it as a matter of courtesy, if nothing else, to everybody.
Mr. Dunlop, can you recall actually when that period would end in terms of our timetable?
Well, it's 3 months for judicial review. I don't know. I think Mr. Armstrong said the decision was dated the 15th of April. That's correct. Then it'll be 3 months from that date.
Oh, it's the end of July, really. Okay. That possibly has that would have an implication on our timetable if the decision was challenged in terms of the relevance of some of the matters raised.
I do appreciate that, and without trying to be unhelpful, it's a decision. I've only recently been instructed by Community Wind Power. It's clearly embarking on such a challenge shouldn't be taken lightly, and it's something they're gathering their thoughts about. They're not delaying. There's no way to set the timetable in this procedure. It's simply something that they have to have a proper think about before they make the final decision.
Right. Okay. We'll maybe look at that implications when we come to look at the other matters, the scope of the matters of the inquiry. Does anybody else want to raise any points on the Section 37 decision at this point? Not its merits, obviously, but in terms of its relevance and implications for us today. Right. I'm not seeing any hands go up. That's fine. Item 5 on the agenda is a caution that I took, which was just to say if someone was going to come forward with an alternative site. Now, that's not an alternative proposal, alternative solution. It's more if they were coming forward with actual land that they wanted the inquiry to consider. There's a set procedure for it within the compulsory purchase rules. I asked the parties to advise me a week ago if that was going to be part of their case, and I didn't receive anything on that matter. Is that still the case? So if anybody wants to raise anything. Mr. Dunlop.
Thank you, ma'am. I don't think we do have alternative, but I just wanted to highlight that there was a letter sent on the 20th of June to Colin Bell at your offices, and attached to that was a diagram showing the route of an alternative underground route. So that is before you, ma'am. What I would say is that doesn't involve the land of any other parties that aren't already involved in this process, this CPO process. So I don't know if that gives you comfort, but there has been in the past, as I say, week, a diagram attached to the letter of 20th of June.
Was that only done in paper and not digitally? You know,
that I don't know. It was sent to me digitally. What I could do, if it isn't of any difficulty, I could ask Miss Donnelly, my instructing agent, simply to come onto the call and confirm how it was sent.
Yeah.
Oh, I'm getting, sorry, it may not be required. I've got WhatsApp. It was by email only. I'm advised.
Okay, so it's digital. Right, okay. Yes. It's just I was getting most of the compulsory purchase order inquiry documents from Colin Bell's email address in the run up till today. Even the stuff that arrived this morning, his colleagues have been forwarding the information on, but I didn't get that particular one. So I'll.
It may be of
Yeah.
no import insofar as it doesn't involve the land of any additional third parties, but it does contain as an alternative underground GGRP route diagram. An old-fashioned screen sharing. I don't know if any of the other parties have seen that, but hopefully.
Can anybody confirm whether they received? Did Ms. Donnelly circulate it to the inquiry participants?
And if you give me a split second. Yes, it was copied to the acquiring authorities, and I'm being advised it can be resent during the course of this morning, if that would be of assistance.
Possibly, just with an alert on it that to pass it through to me, because it doesn't come to me. Obviously, it goes into a colleague's inbox. See what we can do with it. Obviously, I'll take the advice of the other participants here. If the alternatives that are being suggested are already part of the land subject to the CPO, I'm thinking that they're already engaged, and we wouldn't be triggering the formality of the rules. I think it's under Rule 6 to carry out new notification. But obviously, I appreciate the views of the other parties on their interpretation of those rules. Mr. Armstrong.
Ma'am, if I could just correct on one point, I think for the previous item, I think Mr. Dunlop indicated it was the 15th of April that the Scottish Government's decision came out. It was, I think, as I said, the 23rd of April was the date. Ma'am, I can also confirm that we did receive the letter from Mr. Dunlop's instructing solicitors on the 20th of June. It obviously sets out an alternative route, and I would have thought that does bring us into Rule 6 of the 1998 rules. There is also, of course, the Code of Practice, Circular 17, 1998, in paragraph 24, which sets out the party making the proposal should ensure that sufficient detail is provided and should give notice to the owners that could have a possible interest in the proceedings. It is our understanding that the alternative route that is suggested, that all the landowners are represented as objectors here. Although the Forestry Land Scotland do own some of the land, and I don't know if they have been notified by DWF of the alternative that is proposed.
Okay. Obviously, Forestry Land Scotland haven't been identified as a participant as far as I was aware. Does that mean that the alternative route is moving outside the existing compulsory purchase route then?
Ma'am, it is not it's not the same route. It was a route that was considered through the routing process, but it's not the same route as we're considering at this hearing today. But our understanding is that all the objectors here are the owners of the land, other than the forestry lands, Land Scotland, are represented here today.
Okay. Well, my understanding, obviously, if we need to get to the bottom of that is just something that we'll take forward from the meeting, is that those processes need to be put in place. If that additional land is now to be part of the inquiry, case put forward by one of the parties, then I'll need to trigger those appropriate notifications. But you will need to, it will need to come from you, Mr. Dunlop, or your clients to confirm the landowner. I can't, I can't make those judgments myself. So you would need to confirm exactly who the landowner is for each part of this alternative land.
Yes.
But I think that we can do that after the meeting, I think. Absolutely. But it's just something we'll need to trigger. And obviously, Mr. Armstrong's helpfully identify that you have possibly slipped into a piece of land that is not covered by the existing landowners here.
Thank you.
Right. So anything else on alternative sites at this point? We now have one in contention, so we need to. Mr. Woodcock, you've raised your hand.
Yes, Ma'am, I'm not used to this type of inquiry, but it does seem to me, I mean, if we're talking about alternative routes in the term alternative sites, I mean, we've been trying to discuss alternative routes with Scottish Power throughout, but the reaction we've always got is that they're not interested in anything other than what they want. The route that they're now proposing is different to routes that were proposing 2 years ago. They've changed their mind several times about what the route is. We have tried to reason with them about adopting routes that don't have such an adverse impact on us. I can only say that they seem completely disinterested. Their focus is totally on what's the best for them.
Okay, we've kind of strayed a little bit into the merits of the case a wee bit there, Mr. Woodcock. I think the purpose of this item on the agenda is to whether or not a particular rule under the CPO inquiry procedures is triggered, and that's to do with whether or not any objector's case will rely on identifying an alternative piece of land that could be used and therefore should be considered instead of their land. So it's not. I think we're going to come to the nature of alternatives is actually something that perhaps will be the scope of the inquiry. But this is about whether or not any individual case is going to identify land because of a procedural requirement that's triggered by the rules, where you have to go through certain hurdles in terms of notification and engaging with the parties involved. So if, for example, your case that you in due course put forward into the inquiry does not include an alternative pocket of land, then this doesn't affect you. But you may still raise matters to do with how the alternatives were considered. That will still probably be part of the scope of the inquiry because we're going to come on to that next. So I think we've probably covered alternative sites as far as we need to just now, and that takes us on to item 6, which is probably the main thrust of the meeting today, and that's about establishing what the scope of the inquiry should be and whether or not we still need to go through the process of submitting outline statements of case. So far I haven't had that. I've still just got the inquiring authority's response to the objections. You'll see that I've attempted to group the matters that's in Annex A to your agenda. I've attempted to group the matters in sort of a general heading and then ones that are more site-specific to each landowner or interested party. But this is very much my first impression of the letters and the information that it contained. And it really should be considered a starting point for our discussions today. It's not set in stone. It's just the feeling I got to try and condense it down into some headings so that we could talk through whether those are going to be the main matters for the inquiry, and also importantly whether or not, and in fact, they're actually matters to do with compensation. And that would be what we'll be looking at that as we go through these just now. As I went through the exercise and bearing in mind we've got the Section 37 permission and the deemed planning permission, which obviously Mr Dunlop's triggered a potential risk to that, I felt that we really needed to refine the objections a little further. There was a lot of references to just impacts, and there's not always an actual explanation for those impacts. Some of the letters are more detailed than others. Some of them cover matters that are not perhaps directly applicable to the inquiry. And that was why I think really it became apparent that perhaps we do need the parties to really focus in on what their case is in relation to their own land interests. And that's what I'd like to think about as we go through the scope and whether or not we need to get more information to be able to tackle that through the inquiry. Bearing in mind, obviously, the inquiring authority needs to have the opportunity to respond to those points, and to do that, they really need to understand where the problem lies. And I felt in some issues that was not perhaps as clear from the original letters of objection as it could be. So what I'll do in this case, I think perhaps if I let each objector come in first on the list in Annex A, on the matters I've raised sort of on their behalf and generally, and then maybe we can ask the authority to come in at the end or in response to each particular matter, possibly at the end, and we just hear the objector's response to the list first, and then we'll maybe ask the inquiring authority to come back and see if they've got any comments to make. So perhaps just starting with objection 1 and the Buccleuch Estates people, and just this idea of how I'd structured the main matters.
Thank you, ma'am. In terms of objection 1 regarding the Buccleuch Estates, taking instructions from my clients in respect of the proposed points and matters that you raise, and my client is perfectly content in respect of those matters and doesn't have anything to add or necessarily to take away. Insofar as environmental impacts are concerned, this is something that I think my client would be keen to refine further, given that the Section 37 consent has now been granted, subject to, of course, Mr Dunlop's indication that there may potentially be a judicial challenge to that. But with the exception of that particular point, my client didn't have anything further to add in terms of how you had scoped out the various matters that had been raised.
I got the impression, in terms of the specific matters for objection 1, that I thought Buccleuch Estates probably had an interest in those general matters regarding engagement, the prematurity, which may or may not drop out of the inquiry, the alternatives that were being considered, and balancing that against public benefit. I felt those themes actually were quite common to most of the objections. That could be either derived from them, or you could imply them from the tone of the letters that these matters were being raised. Would you agree with that? That these general matters would apply to the Buccleuch Estates concerns?
Yes, ma'am. Obviously, subject to the point around prematurity potentially falling away, I think it would be correct to say that the remaining general matters are those that form a thread through the objection by the Buccleuch Estates and the other companies, the related companies.
Yes, thank you. Objection 2, the Woodcock entities.
Mike, do you want to go first?
Please do, Neil, yes.
Yeah. Mike, do you want to say? Do you want to add any of our specific things that are listed in the agenda?
Sorry, you're asking if they want.
I'm asking if you want to add. I mean, the question from the chair was whether you wanted to add anything specific, or if she's actually captured your site-specific matters, or there anything else you want to address or enhance.
I think it captures the majority of them. I would have concerns about, in particular, about item 2, where the objection is stated as being impact on future developments have planning permission. I know it's a moot point, but there are development projects that we have there which are partly our planning consent, and where other parts of the wider development don't yet have planning permission, and I'd expect those to be considered as well.
Yeah, I've noted that. Yeah, I was there was a lot of references to potential projects, so I'd quite happily remove that restriction to be the ones with planning permission. I think it would be important perhaps that those with permission and those without perhaps are identified clearly, because there is a difference in terms of the timing of the inquiry as to where these projects are in the consenting process. Sorry, on go.
So just one of the things arising also with this, the alternative site being raised, and I've not actually seen the plan. I think that would be, I mean, that maybe impacts on one of our main issues, which was, potential of the working mythology and the undergrounding. Now, knowing where this alternative site is, that might have some effects on particularly the potential of undergrounding. So I think we have to consider that. We have to see that plan. Is there something can work on some of the specific points that we have raised, whether that will be affected by this alternative site and seeing the plan. So I'd like to see that.
Yeah, I've noted that then as the alternative site now suggested could help or hinder your own concerns. Would that be a fair point? It might be positive or negative.
Yeah. It's an unknown at the moment, so that's
yeah. Okay. And just a quick question, just to ask the same as I did of Mr. Devlin. Are you happy that those general points would cover? You would be interested in those general points, with the caveat over prematurity?
Yes.
Yeah.
I think my client would probably like it for the lack of engagement point. I think he would probably like to make a strong point on.
Yes.
So objection 3 from you.
Thank you, ma'am. The bullet points, for want of a better term, broadly cover both my clients' points to be made. I mean, obviously I could develop them, but I don't think that's the purpose of what we're doing today. I mean, in terms of, I suppose, you asked about the impacts. Our principal position, both Drumbuie and Community Wind Power, is that there's an alternative way of doing this using an underground cable. But in terms of the impacts, I suppose it's probably worth being absolutely clear that the engagement with community wind power has been very recent, and we're being drip fed details. So I can't give you exact details of the impacts, but my understanding is that the principal concerns in terms of impacts at the moment are that Tower 11 is too close to the access road, and the height of the cable over the access road would cause essentially difficulties with both operating and maintaining the wind farm. But as I said, the discussions have been very embryonic. The first meeting was, it was less than a month ago. And from that meeting, some further details have been provided to Community Wind Power, but they have been coming in drips and drabs.
The one issue I had perhaps with objection 3, and I know there's a sort of a relationship issue here between, and obviously acting for both parties, was that objection 3 was fairly scant on what the reasons were. I think there was sort of reference to other documents that were not part of the objection letter. And that gave me a bit of concern that in terms of taking forward, setting aside the community wind farms interest, perhaps the overlap, that perhaps we were lacking a bit of clarity as to what potential problems were that impacted on the CPO land, that the authority could then consider and respond to. And it was actually perhaps objection 3, I think that we were needing a little bit more information as to their interest. Obviously, I know there's a sort of overlap between the interests of the wind farm and the landowner, but I think we need to be clear whether what the landowners, the impacts might be on them, separate from the impacts on the wind farm itself.
Absolutely. I mean, obviously, one's the freeholder and one's the leaseholder. In terms of there's nothing different from what was put before the unit for the purposes of the Section 37 consent. I mean, one of the points that hasn't been, and I appreciate it may ultimately be a compensation matter, but is the impact on the quarry, which doesn't appear, but I appreciate that wasn't detailed. But there's nothing, I mean, this is obviously going to be dealt with if there's a statement of case, but there's nothing out with the Section 37 procedure that's new, if you like, in terms of the objections that are made in relation to the CPO. The principal ones being that there's an alternative that's underground, and that is the principal position. There's obviously the additional, as you've identified, to the extent of the public benefit, a claim that the overhead line is only required for 1 year.
Yeah, maybe come back to that in. Just when you say quarry there, I hadn't identified a quarry issue with your landowner. The quarry.
There's a quarry owned by the Walkers, which directors of renewables, which will also be impacted by the development if it were to proceed. It may ultimately be a compensation matter. I haven't had an opportunity to fully consider that, but it is something that was before was considered in the context of the Section 37 consent.
Well, obviously the difficulty is that, I mean, I'm telling you things you obviously know, but the matters that are clearly about the planning permission, the objections to the planning permission are not necessarily ones that are still relevant once we come into the compulsory purchase order process. It's quite hard for me to just transfer across planning permission concerns.
No, I feel it.
And it's about filtering down so we actually find out what remnants of those concerns are actually still relevant now we're looking at compulsory purchase. And without that, without your translation of those matters, it's difficult for me to work out which parts of these letters I don't have would actually be relevant here in the inquiry sessions.
Yes, I'm sorry, I'm just looking to see if there's a... Sorry, I thought I was getting a WhatsApp message through there. No. My understanding is that the quarry issue will come down to essentially compensation. I wonder if there's going to be a short break, what I could do is I could clarify that point with my agents. I think it's unlikely we're going to get this finished shortly. So I wonder if I could just clarify that at the break, and that might be something that would be helpful on me stumbling through a submission.
No, that's fine. What we'll do is we'll keep going with item number we're on. Item 6, and we'll take a break at the end of item 6, and then we'll come back in that. So I'll finish item 6, then we'll take a break.
I'm grateful. Thank you, Mum.
So, well, I suppose when you're still speaking, Mr. Dunlop, obviously I'd put the wind farm matters in one section on the assumption that not necessarily that I expected a combined presentation from the two wind farm companies, but more that perhaps their issues were similar, and perhaps in terms of the acquiring authority's participation, it might make sense for wind farm issues to be grouped together, allowing the acquiring authority to look at those issues as a sort of a single matter for them in terms of their case or their witnesses.
I think that's true. There's certainly, obviously, I've always got to be conscious of the conflict issue. So as I read matters presently, they are aligned in terms of Drumbuie and CWP are aligned in terms of what their objections are going to be, but they will have separate. There'll be separate. We'll come on to that, but there'll be witnesses from both CWP and witnesses from Drumbuie that will speak. In terms of the experts that will speak, I'm anticipating that will be a joint instruction by CWP and Drumbuie. So it will be a combined force, if you like. Yes, I have to say, when I was looking at the bullet points for the wind farm matters, which I fully agree with, I did wonder if objection 3 almost kind of fell into some of the bullet points in wind farm matters. It was hard to see. I wasn't entirely sure how we would comfortably carve those up, if you like, if there was to be separate sessions where only Drumbury. Yes,
I would agree with you. I think that just the objection 3 was not so clear on where it's at with the wind farm matters. It was a bit too general at the stage that we have. So that would make sense. So that's quite good. That's helpful. Thank you. And that then takes us to objection 6, which is the other wind farm.
Hello, yes, I can confirm that we are comfortable with the list of inquiry matters as it is. The ones which are most relevant to us are the first bullet point in the general, and then the second and third bullets in the wind farm matters.
Right. And if I return to the authority now to Mr. I'm sorry, Mr. Woodcock. You're speaking, Mr. Woodcock. Are you wanting to come in at this point? No. I think your microphone's going on and off, Mr. Woodcock. I'm not sure. Are you speaking?
I don't wish to speak at this stage.
Right. Okay. So just keep your microphone off just now then. Thank you. Mr. Armstrong, I was going to let you come back on the overall list and any comments you have on the other parties' positions.
Thank you, Ma'am. And perhaps we would just go through the list in Annex A, and in relation to the general points, the 5 bullet points, I've got sort of three issues to raise. The first one is obviously others have raised the question of prematurity, and that would appear on the face of it not to be an issue now that the Scottish ministers have issued the consent, although I know what Mr. Dunlop has said today. The second is in relation to the third bullet point there, the alternatives considered for location of the substation and route of overhead line. And I suggested it would be useful perhaps also to put down there the undergrounding. And we've obviously now got the position in relation to an alternative line being advanced in relation to undergrounding. And could I suggest it would be helpful to have a general session where we can discuss sort of methodology, policy issues, and relevant considerations, not just in relation to the alternative considered for location of substation and route of the line, but also on the issue of undergrounding. That would avoid these points having to be perhaps put forward at 2 or 3 sessions, and instead they could be addressed at one session in the general section. And the third point in relation to that general list is that I think it would be useful if perhaps we had a general session in relation to transport and access arrangements. We also have, well, we have the advantage of the Section 37 consent and the condition in relation to transport plans. And I think it would be useful, rather than perhaps the sort of policy and general access principles, routes, heights, etc., could all be dealt with at a general session, rather than the same evidence being perhaps led at several different sessions. I appreciate that there's obviously site-specific matters, but I'd have thought that it would be helpful to have a general session in relation to transport and access arrangements. In relation to the site specific and turning to the Buccleuch Estates first and the matters identified. And in that first bullet point, there's the reference to forestry and environmental impacts. Well, again, we've obviously got the Section 37 consent, and we've got the Scottish Minister's position in relation to these matters. And so I really do wonder if there is really if there are any issues left in relation to these matters for them to form part of a specific issue. In relation to the the fifth bullet point, impact on fishing rights. Again, this will have to be seen in the context of the Scottish Minister's consent, and I'm thinking of, in particular, the conclusions at paragraph 74 of that consent. And I think it'd be helpful to have some clarification from Mr. Devlin today what exactly the point is in relation to impact on fishing rights. And is this a matter that's perhaps more directed to compensation? Because clearly the Scottish ministers have addressed and considered this issue in the context of the consent. In relation to the Woodcock entities objection, the third bullet point there, impact on on the public habitat trail. Again, this is a matter that was dealt with in the consent by the Scottish ministers, and again, I wonder whether this is still a relevant issue in light of, in particular, paragraph 70 and 71 of the Scottish minister's letter. It would also be helpful to have clarification of which specific public habitat trail is being referred to. The fourth bullet point in relation to the Woodcock entities' impact on fishing rights, again, my points in relation to the Buccleuch Estates objection would also apply to that. In relation to the last bullet point of objection to the Woodcock entities, the authority's commitment obligation to paying professional fees incurred in the CPO process. I do question the relevance of that, particularly having regard to paragraph 66 of Circular 6 of 2011 and the Scottish Government guidance, in particular the guidance for property owners and occupiers at paragraph 3.1.12 of that document. And I would submit that that is not a relevant consideration for the inquiry session, having regard to the government guidance on this matter. In relation to the Walker's objection 3, firstly, it would be helpful to have clarification in relation to the quarry matter that Mr. Dunlop referred to. I think it's referred to as Borrow Pit 3 in the letter, but again, it would be helpful to have clarification where exactly that is and what is the argument in relation to that. I do have some concerns in relation to the letter of the 20th June 2024 from Mr. Dunlop's instructing solicitor, where there is reference to the objections to the Section 37 consent. You obviously, Ma'am, do not have these objections before you. There would appear to be 4 of them that are from the Walker entities, if I can call them that. The main one appears to involve a series of emails and is primarily in relation to criticism of the EIA report. Again, these matters have been dealt with in relation to the Scottish Minister's decision on the in relation to the Section 37 consent. And I would submit they are no longer relevant, certainly in the form that they were set out in these objections. You clearly don't have these points before you. If there are issues still relevant, it would be helpful to know what these are at this stage and to have further better particulars in relation to them. But if it's primarily just a matter of saying that the Walker entities consider that the Scottish ministers got it wrong in relation to their conclusions, then I'd submit, Ma'am, that isn't a relevant point for to be considered in the inquiry. These are the only points I have in relation to item 6.
I was going to ask then, just to come back to you on, and it's the legal matter which I'd put under wind farm matters, and that was raised by objection 5. And that's this idea of the licence holder under the Electricity Act not being able to interfere with another Electricity Act licence holder. And it seemed to be a particular concern that it might impede granting the compulsory purchase order in part or completely if it could be seen that there were impacts on another licence holder's interests. A legal point from my point of view, and I don't really have any details other than the reference to the legislation that refers to it, which is rather simple in its terms. It's not telling me what I should be considering or how I ascertain these particular problems. So I'm just wondering if that is a matter for the inquiry or a separate legal issue to be resolved separately as to how you tackle that particular provision of the Electricity Act.
Ma'am, I was envisaging that clearly the evidence that's led in relation to the impacts on the relevant wind farm would clearly have an input in relation to that 4th bullet point. And what I'd anticipated would be that we would hear the evidence on that, and then there would be, as part of the closing submissions, there would be arguments on how that evidence either does or does not have an impact in relation to the Electricity Act issues.
Okay, yeah, no, that's good. So it would just fit as part of the evidence would help me answer that point for ministers in their consideration of the order. Well, if we take a break just now at 11:15. Sorry, Mr. Dunlop, you want to come back in before we finish just now?
It was simply to echo the views of my learned friend, Mr. Armstrong, that essentially I think there has to be evidence-led before we can address the legal argument. Essentially, a proof before answer, I suppose, in conventional court terms.
So what we'll do, we'll take a 10-minute break just now before we go on with the rest of the agenda. That'll allow you to kind of have a chat, update anything you need to. Don't leave the meeting. Just turn your microphones and cameras off if you want to. And we'll come back at 11:25 and just pick up the agenda, and we'll get any updates on item 6 before we proceed. Okay. Thank you very much. Oh, that's 25 past. Is everybody ready to proceed again? Right, I think that's everybody back paying attention. That's good. Mr. Dunlop, I'll come back to you on if you want to update us on where you were just before the break.
Yes, I mean, I took instructions rather swiftly, as to be said, but I appreciate that it's important. In terms of the quarry, the difficulty is that the development works would impact on accessing the quarry. So essentially, the issue with the quarry really is linked into the alternative that if the underground cabling and the alternative route was considered, that wouldn't be an impact on the quarry. An impact on the quarry would be the daily operation of the quarry because of the impact on the access road, which is a similar issue. One of the issues for the wind farms is the access road. I think I identified earlier that one of the things that Community Wind Power are looking at the moment is the cabling which would run above the access road for Tower 11, which would be at such a height that wouldn't enable vehicles that would require to come in for maintenance purposes to use the access road.
Maybe just ask you while you're got your live mic, what do you consider then to Mr. Armstrong's suggestion that we look at access issues in the round?
Absolutely.
And deal with it as a general matter, that we actually pull out all the access matters and we look at transportation matters, whether they're wind farm or not, and how sharing the access routes or however this is going to work, whether how that impacts on the other party's interests. Would that suit your client?
Yes, I think that's an entirely sensible way forward.
Can I just ask the other parties then how they would respond to Mr. Armstrong's suggestions of those slight changes to the items, certainly in the general topics, which was adding in transport matters as a general issue, I suppose expanding the alternatives heading to include methodology and policy around deciding on alternatives or reviewing alternatives through the design process, and making it clear that the alternatives include not just a route, but also the concept of undergrounding. So just to come back to maybe starting with Mr. Devlin, do you have any thoughts on that?
To considering these matters in the round, I think that seems like a pretty sensible approach to take.
Thank you. Objection 2, Mr. Forster Smith and Mr. Stringer?
Yes, we'll agree to that as well. It's sensible.
And we've got Mr. Dunlop. So just Ms. Purvis for objection 6.
We're comfortable with that as well.
Right. Does anybody then want to come in with any other comments they've got regarding Mr. Armstrong's suggestions generally, the other implications for the way the process, perhaps, certain items that might actually fall away because they're too closely related to confirmed issues that have been resolved through the Section 37. Is anybody able to come back on that in terms of whether they feel it should still be part of the inquiry? Mr. Devlin?
Thank you, ma'am. Yes, it was just in relation to Mr. Armstrong's suggestions regarding, I think it was forestry matters and fishing rights. I did try to get a hold of my client during the break, but wasn't able to do so. My instructions are that we're comfortable with those continuing to form part of the site-specific matters, certainly for my client's sites. Obviously, it's a question for you, ma'am, whether or not those matters remain included, and perhaps it's just a point that would be more fully fleshed out as part of a statement of case procedure.
Mr. Woodcock, sorry, I overlooked you because you were in the sidebar. Mr. Woodcock, you wanted to come in on that matter? Sorry, Dr. Woodcock, apologies. Are you still there? Oh, his hand's come down. Don't think he's contributing on that point. Well, I have to say, hello, Dr. Woodcock, were you wanting to come in on that point?
Yeah.
Responding to Mr. Armstrong's matters?
The 2 points I want to come in on is, firstly, I agree that looking at access in the round is the right thing to do, because we certainly have issues concerning access stemming from the heads of the Valleys Road, which has not been mentioned and which impacts on a great many people, and the use of the road that now Scottish Power seem to think that they can just use without recourse to the use of that road by the people who actually own it and pay for it. And so that is a big one from our point of view. And the second thing I would like to say, when we cut off about when the Scottish Power representative was looking at the last of the bullet points on the objection to the commitment to pay professional fees, and seemed to think we should not be considered, we would not wish to concede that point. We have been trying to get our outstanding expenses from the acquiring authority for years now, without success. We've had representatives trying to represent us who refuse to do any further work because they won't meet the professional costs that are necessary part of that. So I would just like to make the point that I believe that needs to be considered by the inquiry.
Does anybody else want to come in on anything? Mr. Armstrong, would you want to come back on any of those points?
Well,
So, yeah. My question then is perhaps more of a loaded one, is whether or not there is benefit now in looking at the timetable, before we look at the timetable in detail, is whether or not we slot in an extra phase of a number of weeks that allow these cases that we've been discussing today to come in as outline cases, so that we can then tailor the inquiry timetable much closer to what are the remaining matters that are not fully resolved. So that was really where I saw this potentially having to go, that we look at getting another outline statements of case for everybody, where we pick up all the kind of missing information, where you've been drawing from documents that aren't before the inquiry, things that I can't make a judgment on because they've not been available. We can obviously look at the alternative route. I've been sent that document now in the break as well, and that we then push the inquiry timetable back to allow an exchange of outline cases that allows parties to refine where they are or expand a little bit more on things that are a bit vague at the moment. And then we reconvene a pre-inquiry meeting that then settles on the actual inquiry sessions and actually the matters that would be considered in each particular session. So I'm really looking for your view on that before we look at the timetable itself, and to see whether you think there would be benefit in slotting in that and accepting that it perhaps pushes the inquiry back a month, but it actually then might refine the inquiry down to a much more precise set of topics in the interim period. So perhaps starting with Mr. Devlin and work through the objectors first.
Thank you, ma'am. Yeah, my client would not have any objection to that, in particular on the basis that, as was mentioned at the outset, my client is in negotiations with the inquiring authority, and indeed that may afford an additional period of time to enter into a voluntary arrangement, if indeed that is possible.
Objection 2 then, Mr. Stringer or Mr. Forster-Smith, if Mr. Stringer's missing.
Mr. Stringer is indeed missing. No, there is no objection to that proposal in respect of procedure. As Mr. Stringer mentioned earlier, it is hoped that a meeting with the acquiring authority will be scheduled in the coming weeks. So again, it will just allow some further time for that to take place, and perhaps, if possible, reach a consensual agreement.
Objection 3 and possibly 5 then, Mr. Dunlop.
Thank you, ma'am. Not only would we not object, I think we would welcome the opportunity. As I've indicated, there's CWP have been involved for a relatively brief moment in time, and we're looking to get experts on board, so additional time would be welcomed, and it would suit all of our diaries, actually, because at the moment the timetable's looking rather soon.
Yeah. And then objection 6, Lynette.
No objections. Thank you.
And then Mr. Armstrong, faced with overwhelming support for slotting in an extra bit of process to help refine the matter, so do you have a view on getting an outline statement of case before we actually confirm the inquiry sessions?
Well, ma'am, it's obviously what ultimately best helps you and what you would prefer. Although I would have thought that we could still have, if you feel that it's appropriate to have outline statements of case, we could still set a timetable now, so as people, have in their diary, have the dates that they've got to be available for, as I'm sure you appreciate with all the parties here, that their diaries do change. And I think if the longer we leave this, then it's harder to get everyone back at an inquiry session. We actually think, Mom, that your Annex A that does set out really a detailed list, a refined list of the matters to be dealt with. Its focus on the key issues, and we wonder if outline statements of case would really add that much more to it. We have the points there identified, and the next stage is for people to set out their position on them, and I think that could be dealt with in the normal procedure of statements of case, or if we're going to hearing statements, rather than having the additional outline statements of case. And certainly from my recent experience of doing inquiries and hearings, the outline statement of case procedure doesn't seem to be used as often as it was in the past, because obviously parties have got to set out, well, first of all, you have the details as you have set out the inquiry matters in Annex A, and certainly secondly, you have the either the hearing statements or the statements of case, and to an extent there's just a replication, and I've certainly been involved in one inquiry earlier in the year where it did appear that there was parties were ending up having to say the same thing about 3 times in outline statements of case, and hearing statements. So our preference would be for an amended Annex A, which sets out the matters, and then for parties to work towards producing their evidence in relation to the issues identified in the revised Annex A, without the need for outline statement of case. But ma'am, if you feel that would help you, then then we certainly don't take an issue about having an outline statement of case, but we would be keen to set a timetable today, if at all possible. Obviously, if you're going to have outline statements of case, there'd be little point in having an outline statement of case and then sort of a week later a statement of case or a hearing statement going in. So that might mean moving towards the rather than the September start, a sort of slightly later start if you're wanting to have an outline statement of case.
Yeah, I was aware of that once I put that extra process in and allowed people to think about it and potentially some exchange of views if necessary on certain points, that September became very difficult. And that's why I'd sent out with the agenda itself that the original inquiry dates that I'd looked at were getting tighter and tighter because of that, and that October might actually work better for other reasons. If I could take something just slightly out of sequence, because I think it might help a little bit from my point of view, is just generally, is everybody happy that this proceeds as an online inquiry or hearing session and that we conduct business really as we're doing today? Because obviously that can make a difference to how I timetable it through the DPA. So if I go back, I know I can get an online inquiry the week beginning the 9th of September, for example, but in person becomes a little bit harder because of other staffing commitments and potentially, and obviously webcasting is likely to drop away from an in-person event of this nature because our webcasting capacity is limited and the CPO inquiry process is quite focused on a smaller group of individuals rather than a general public interest. So it really can we get an answer on the idea of just staying with an online process at this time? Mr. Dunlop, you wanted to come in on that point?
Yes, I think my client's preference in the first instance would be an in-person. I think it largely depends on how the sessions are going to be conducted, because it's not clear which will be hearing sessions and which will be
we don't know yet. Mm-hmm.
But certainly in terms of for inquiry sessions and for hearing sessions and with the number of people involved, I appreciate my clients are just two of a number. Their preferred route would be by in person.
Okay. Mr. Devlin?
My client doesn't have any strong preference either way.
Mr. Forster-Smith?
Thank you, ma'am. I don't have any particular instructions on that, so I'd have to defer to Mr. Woodcock for his view on that, right?
I have, yes. We have discussed.
You've disappeared there, Mr. Woodcock. You've muted your mic, I think.
Hello.
Yes. Do you have a view on an in-person event, i.e., in a hall or event venue, versus doing an online inquiry or hearing session where we would use this sort of format with the Teams system?
Yes, I understand the question. I have considered it with our leading solicitor, and we're very much in favour of an in-person inquiry, not online.
Ms. Purvis?
We have no strong preference either way.
And Mr. Armstrong, what were your thoughts on?
Ma'am, our preference is in person rather than online. Whilst online can be, very effective, particularly when there's perhaps only two parties involved. When there are a group of parties involved, and perhaps over a day or two, certainly in my experience, in person is preferable to online, particularly if one person, for whatever technical reason, drops out, it often means that the whole hearing or inquiry session comes to an abrupt halt until they're back on if they don't have a representative during the session. So our preference is very much in person. It is perhaps more dealing with later items, in particular item 7, but again, our preference would be for the hearing procedure for most of the issues identified, and for some of the other issues, it would be a preference for written submissions. And again, in my experience, hearing sessions, when at the hearing procedure, when there's a number of parties involved, it is better for that to be in person, where there can be a genuine discussion between the parties around a table, rather than the slightly stilted everyone having their sort of say and then sort of coming back round the parties, rather than getting involved in an actual discussion about the key issues. On the position of recording, my clients can make available a shorthand writer to record or take note of the evidence if that assists ma'am in relation to the sessions.
No, I think it's fine. It's not, my recording of it is fine. It's more just for public. It's more the kind of general public view, if there were people that were just wanted to kind of follow the event as opposed to participate. So the reason for asking it really was to drop in from where we are with the scope of the items as to how we kind of take them forward and whether we have the outline statement of case. So if I go back to that, my concern for the outline statement of case was really actually, in a way, it was looking at the acquiring authorities' interest, because I felt that perhaps they might benefit from a little bit more clarity on some of the more general terms in some of the letters, with things like the word just impact on. It meant that there was less clarity as to what these impacts were, whether it was impact on operation or possibly straying into impacts that were compensation matters. And I think that was where my concerns for it was some of the lack of clarity meant that I couldn't really be sure whether or not we were bringing forward compensation matters into the inquiry by accident. And so that was really my reason for it. But actually, I've no strong views. I mean, if we can keep the inquiry timetable moving forward and progress to statements of case or hearing statements, we'll come to that in a minute, then I'm quite happy with that. I'd rather keep the process moving. Mr. Armstrong, do you want to come back on that?
Yes, I mean, certainly on the notice of what the case or the objector's cases are. I mean, I think if parties are, if we have an agreed list of inquiry matters, which we seem very close to, which sort of is a slightly amended or adjusted Annex A, then parties have got to address the issues that you've identified as the relevant issues. And so there wouldn't be really an ability for parties to stray from that, because you've identified the issues that are important. And it seems that we've got general agreement today, or an acceptance of what the issues are. Clearly, if parties were wanting to raise other matters that aren't contained specifically in there, that aren't identified in their objections, then that raises another issue. But it does sound as though everyone here today is broadly or generally agreed on what the issues are and what they've got to address. And so I think that on that basis, the having the outline statement of case would perhaps be sort of surplus to requirement if parties are accepting these issues, subject obviously to the tweaks that have been suggested by parties today.
Yeah. Dr. Woodcock, you had your hand up. Dr. Woodcock, you're still muted, so if you're trying to speak to us, you've muted your mic. Are you there, Dr. Woodcock? I'll maybe come back to you. Mr. Dunlop, did you want to come in?
Yes, if I understand my learned friend, Mr. Armstrong, correctly, I think what he was proposing was that a revised Annex A would be produced, and that essentially might, I suppose, do away with the need for an outline statement of case. I think that's a sensible approach. I think with parties maybe being given 7 days to comment on the amended Annex A, just in case there's anything that hasn't been missed, and then those points can obviously be dealt with more comprehensively in the statement of case, hearing statements, however we're going to be dealing with the procedure.
Yeah.
Yeah, sorry, I was just going to say.
I'm just going to say that seems a sensible solution, that I issue an Annex A as soon as I can after today's meeting, and we have a little bit of online comment on that until it's settled, and then we progress with the timetable thereafter. Dr. Woodcock, were you able to come in now?
Hello?
Oh, yes. Did you want to come in on that point? Sorry.
No, I'm content with where we are.
Okay, thank you.
Content.
So if we are putting outline statement of case to the side, because we've got enough information to move forward, then perhaps we look at then the procedure, because that would then to a certain extent dictate the timescale. Mr. Armstrong suggested that I don't know that you were suggesting inquiry process for anything there. You were looking at trying to use hearings for the bulk of the items we've discussed.
That's correct, Ma'am, and written submissions for some of them. I don't know, Ma'am, if you want, I could go through my suggestions in relation to Annex A and the various matters that you've identified. Put forward what I would suggest would be the appropriate procedure, whether it be hearing or written, and then other parties could perhaps come in after that.
Yes, that would be very helpful. Just to double check, obviously everybody's well represented here by knowledgeable lawyers. Is everybody happy with the differences between an inquiry, or a hearing session, and then the use of the written submissions? Ms. Purvis?
Yes, my clients would benefit from a summary. Thank you.
Right, okay, that's fine. So basically, the three different techniques that are used generally through planning or other inquiry processes is an inquiry session itself, which is quite formal. You present evidence. In turn, you need to have witnesses to present that evidence, and those witnesses are subject to cross-examination by the other parties participating. You need to provide a statement of case, and then you need to provide precognitions that sets out what that witness's position is on any of the matters in the inquiry session. You're usually needing some kind of legal representation, not necessarily a KC, but obviously it benefits from having a separate person who then leads evidence and that does the cross-examination. They are formal, and they have a certain court style to them, but they are done through the DPA process, which is slightly less formal. It's not quite as rigorous as a formal court session. I certainly don't like seeing myself in the role of judge and jury in these things, so it's much more of a chaired inquiry session. The hearing sessions are different, and as Mr. Armstrong said, they are you are more engaged through the hearing sessions. There's a structured discussion. I lead the discussion as the chairperson. I create an agenda, and it's my questions that you're answering, or you are making your case at my invitation. You don't get to cross-examine the other people around the table, but you can raise points through the chair, me, as to how you would like a matter to be addressed if you don't feel it's been covered in a certain way. So it's a structured discussion, but it does allow, as Mr. Armstrong said, there's a bit more of it's more fluid, especially if you're all in one room, because the discussions can actually flow back and forward quite easily. You don't need to have legal representation in those situations. It's up to you to decide how you would want to put forward the best person to lead those discussions in the room. And then for written submissions, what I would do as part of the procedure notice is I would set out the topics that I think, obviously with your agreement today, that could perhaps be dealt with by an exchange of views. So the written submissions would come from the objectors setting out their position on particular matters, and on the whole you would then give the acquiring authority a right of response with their position on those same matters, picking up any concerns that you've raised. And that allows me to see, just in written form, how you're approaching those matters. It's often written submissions are often quite good when the issue is very narrow and precise, or it's a procedural matter where we're actually looking at guidance or something similar, and you can actually be quite a focused document. So really that's the difference. So when Mr. Armstrong sets off on his sort of suggestions, you can see a wee bit how he thinks those matters might merit being discussed through the inquiry. We use inquiry in this case, we're using inquiry as the whole process, and we slot in hearings or written statements. They're still part of the inquiry process in the round. Is that sufficient, Ms. Purvis? Has that been helpful? Thank you. So, Mr. Armstrong, can I take you back to where you're about to go then with your suggestions based on Annex A?
Yeah, yes, ma'am. Certainly in relation to bullet point 1, level of engagement, we thought that might be best dealt with by a written procedure where parties can set out their points and come back. And just on written procedure, one way we suggest of possibly doing it would be that parties put in their written submission, and then there's an opportunity for a rebuttal or a response, maybe a week later or something along that sort of time scale, to come back on any additional points. So the first one we suggest written procedure. In relation to the second one, you've obviously got my submissions on that, but again, to suggest that we'll know for certain in relation to whether there's any challenge by towards the end of July. But can I suggest at this stage that this written procedure is also earmarked for that one. The alternatives considered, I think that best served by a hearing, and the extent of public benefit and the pluses and support of the proposal balanced with the arguments advanced by the objectors, we'd suggest that would be a hearing session as well. In relation to the interference with human rights, well, that's very much almost sort of legal submissions, so I suggest that could be done by written submission as well. In relation to the wind farm matters, we consider that should be a hearing session.
Could I just stop you a minute, Mr. Armstrong? Remember you were slotting into the general topics a session on transport matters into the general session. Would that also be a hearing? Because it takes a little bit of the wind farm argument with it, I think, the transport matters.
It does to an extent, but I suppose it's dealing with a general point rather than perhaps any site specific or perhaps wind farm related directly specific matters. And yes, ma'am, I'm obliged to remind me of that. That would be a hearing session as well, we would suggest. In relation to wind farm matters, we think that a hearing session would work. in relation to these points, and obviously there would be the opportunity for a closing submission in relation to any Electricity Act points and in general in relation to the evidence. In relation to the site-specific, starting with the Buccleuch Estates, you've got my submission in relation to the bullet points there. I would have thought that the need to extinguish all rights over plot 50, that again could perhaps be dealt with by written submission, but otherwise I'm happy for them to dealt with by hearing session or suggest a hearing session. And in relation to objections 2 and 3, again, we'd suggest a hearing session. You've obviously got my submissions in relation to the paying of professional fees point. But I'd submit that if you are going to allow that as an issue, then that could be dealt with by way of written submissions. There is also, I'm conscious that, whilst I said at the start that we anticipated, or we were hopeful that the Kilpatrick objection would be withdrawn. Could I suggest that we keep open the possibility of, or put the Kilpatrick specific objection down for written submissions? That would allow that if in the event of the next few weeks that objection is not withdrawn, then the site-specific issues in relation to Kilpatrick would still be dealt with, and that would give Ms. Kilpatrick and her representatives an opportunity to come back on any points, and for the acquiring authority to come back on points.
Yeah, thank you for. I was actually. It was in my mind as to what to do about objection 4 if it wasn't resolved, because there is a kind of this issue of impact on, I think, another quarry, their own quarry at the southern end of the project area. So that's actually quite useful. If we build that in, then the provision is there. The difficulty with them not coming to today's meeting is that it would be preferable for them to have had the opportunity to at least comment on that. But I think perhaps I can cover that by sending them the outcome of the pre-inquiry meeting and hopefully reassuring them that we're still have a mind to their concerns. The only thing I would perhaps put back is I know you were looking to see if you could exclude the fishing rights and the habitat trail, both that are relating to objection 1 and objection 2. And I'm wondering whether they are written submissions matters, because I wasn't sure of whether the effect on fishing rights was because the fishing rights were going to be removed, or whether physically someone just can't fish because there's an overhead line and it's dangerous. So I wasn't entirely sure what the impact on the fishing rights were, because if there wasn't actually intention to acquire them, I wasn't entirely sure what the inquiry would be considering. I don't know if Mr. Devlin, if you had a view, because obviously it's one of the points in your objection from Buccleuch Estates.
Yes, thank you, ma'am. Answering first of all your question directly in respect of the fishing rights point, I would be perfectly happy for that to be dealt with by means of an exchange of written submissions. Perhaps just take this opportunity to comment on Mr. Armstrong's other observations.
Perfectly. Yeah.
I can't say that I've got any strong objections to what he has raised. I was going to suggest that pretty much all of the matters in respect of the site-specific matters regarding my client's objection could potentially just all of it be wrapped up into one single sort of hearing session, but that may not necessarily be practicable. I don't have any objection at all to impact on fishing rights being a written submission. And I think Mr. Armstrong suggested that the need to extinguish rights over Block 50 would also be a written submission. That would be absolutely fine as well.
Objection 2 from the Woodcock representative. Mr. Forster-Smith or Mr. Woodcock?
Thank you, Ma'am. I don't have any comments to make. I probably agree with my friend Mr. Devlin that the impact on fishing rights perhaps is a matter for written submissions, but otherwise I'm in agreement with Mr. Armstrong's proposals.
And objection 3 and 5, Mr. Dunlop?
At the risk of being the troublemaker round the table, yes, I don't agree entirely with my learned friend on a number of the points. I wonder if I can just take 5 minutes to go through them and explain
fine.
my reasoning. The first one, the level of, so dealing with the general heading, and there's 5 bullet points, but there's only 4 which affect my clients. And the first one's level engagement with parties holding interest in the land. And it was suggested that could be dealt with by way of written submissions. My position is my clients are quite passionate, and particularly CWP, Community Wind Power, quite passionate at this point, insofar as they really only have been engaged in the past month, and we would prefer a hearing session in relation to that point, just to, I suppose, drive home the points that we want to make, rather than it just being dealt with. And I appreciate that that doesn't mean that less weight's attached to written submissions, but they would like the opportunity to be heard on the point. That's bullet point number 1. Bullet point number 2, we had thought a hearing, but now on reflection, I suppose I say this without necessarily having discussed it, the prematurity argument's either going to be that either there will be an active judicial review or there won't be by that point, and I think that probably can be dealt with by written submissions. It may fall by the wayside if no challenge takes place. In terms of the next bullet point, the alternatives considered for the location of the substation and the route of the overhead line, to some extent this overlaps with bullet point 3 under wind farm matters, the benefits of underground cables and the realignment of the route, and also to bullet point 1 under objection 3, which is the preference for underground cables or realignment of route under Drumbury, Renewables and Walker. To me, in my submission, those 3 are very much interlinked, and those are, if I say that they're essentially the principal arguments that my clients are going to be advancing, both through witness evidence and through expert evidence, and we would prefer that that point was dealt with at an inquiry session rather than a hearing session. The next point is the extent of public benefit claim that overhead lines only required for 1 year. Again, we thought that that would require evidence. I think, I could be wrong. I think, no, I'm wrong. Sorry, Mr. Armstrong did indicate that hearing for that could be dealt with. So that could be dealt with at a hearing. Transport matters I haven't discussed with my clients. I think the suggestion was that it would be a hearing. I don't have instructions on it, but I don't see a difficulty with that. Looking under wind farm matters, the ones that are of interest to my clients are bullet points 1, 3 and 4. 1 could be a hearing. 3, as one I've already talked about, I think that the underground cables and the alternative route, it does overlap. So that's the point that essentially if there was to be a session on that, we would prefer that it was an inquiry. The final point, the ability of the CPO to interfere with the rights of a licence holder. I mean, I understood what my learned friend was saying is that we would need to hear evidence before we could deal with that point. I wondered if that needed to be a hearing, and that's certainly could be wrong, but that was so either a hearing or written submissions. But it's likely that at some point somebody's going to have to say something that may overlap in that point. I think that deals with them all, because the only other one that's of interest to my clients falls under objection 3, and as I said, it tends to the preference for the underground cables and the route in my submission falls under bullet point 3 of general and bullet point 3 of wind farm matters. They're so closely aligned that I don't think you could separate them, or it wouldn't be administratively convenient to attempt to do so?
Yeah, just before I take that, I was looking at that, this idea of a sort of time management and engaging with the same arguments maybe in multiple places. And so I take your point that pooling certain matters, even though they're about wind farms or they're about other land interests, that we're actually looking at perhaps the access issues together, which was Mr. Armstrong's suggestion, and also the alternatives, because the alternatives seem to be both about wind farm matters and other land interests. So I can appreciate where you're coming from, is to pull some of the site-specific matters up into an overarching session. Anyway, to go on to the other parties, and I think that would leave us with Lynette Purvis and objection 6.
Yes, no objections to a hearing for the bullet 2 of wind farm matters.
Would you want to be involved in the general matters then, if we're pulling up transport alternatives, public benefit, all into sort of into a hearing, either hearing or inquiry sessions? Would you still want to be involved in those?
And we'd like the opportunity to be invited. The first bullet point is the one that's the most relevant to us, which is the level of engagement point.
Right, okay.
And also the benefit of underground cables point as well.
That takes us into the whole broader issue, which was trying to take alternatives and undergrounding as a sort of bigger issue. And it brought in issues of methodology and policy, I think, that Mr. Armstrong had suggested earlier on this morning. Does anybody want to come back on any of those points before we kind of make any decisions? Mr. Armstrong?
Come back on one point in relation to my friend Mr. Dunlop's comment in relation to an inquiry session for this, if we could call it the alternatives. The advantage, obviously, of a hearing session is that there will be a number of experts, obviously, giving evidence on that, and there may be a degree of overlap between experts. In my experience, it works very well with it, that type of issue, dealing with a sort of roundtable discussion at a hearing session, which could be dealt with maybe in one day or perhaps at most 2 days, with all the various topics. If it was to go to an inquiry, and clearly there'd be a number of witnesses from a number of parties, I would envisage, certainly from my experience, that inquiry would probably take 4 or 5 days, with the number of witnesses involved, and each witness being examined and cross-examined.
Mr. Dunlop, do you want to come back on that?
Just to say that I don't think either of my clients will die in the ditch over it, as long as it is dealt with by way of an oral session, if I put it that way, where there is obviously a full opportunity. I wouldn't want it to be any kind of abbreviated procedure, because it's obviously, this may be a kind of silver bullet, if you like, for the objectors.
Yeah. Well, yeah, I think obviously if we're looking at hearings as the main oral procedure for a substantive part of the objectors' cases, it does it gives me a fair amount of responsibility, because then obviously I'm asking all the questions and structuring the discussions. To some extent, sometimes that the inquiry process for the alternatives would be helpful, because obviously it allows other people to then look at the key points, and not just me pulling out these points and directing the discussions. but I see obviously your concerns that we might end up with a 4 to 5 day exchange that could be curtailed by the hearing. Does seem to make sense, especially if some of the evidence perhaps is overlapping about the impact on access routes and things. Mr. Dunlop, do you want to come back on that?
No, in fairness, when I had a relatively early consultation with both clients this morning, and I was giving them advice. I mean, I've got H, oblique I written against some of these things. So as I said, it's not something that I'm going to jump up and down about. We came to the conclusion that an inquiry maybe, because it is, I suppose, the most critical point. It's a, but as I said, it's not something that I'm not getting any WhatsApps and it coming through at the moment going, it must be an inquiry. So, I think they'll take my advice on it. So I can see, I understand where my learned friend's coming from in terms of timescales as well. I think as long as sufficient time set aside, so obviously we would need, I think, at least 2 days for this point.
Okay, so if I could summarise where we've got to, we would, I need to write this down before I forget it all. So we'd be hearing sessions for alternatives as a broad subject matter, a hearing for public benefit as a concept, including the actual need for the line. That point was made about the fact that there's potentially other solutions to moving electricity in the area might come forward. A hearing on access / transport matters. Which could pick up, well, I really would want some clarity whether we're picking up wind farm matters or leaving the wind farm access issues to sit within a separate sort of wind farm, if I call it that, a wind farm hearing, so that we were actually looking at all the wind farm interests in the same session. I don't know how anybody feels about that. That was what was worrying me a wee bit. If once we have some of the access discussed in a transport access session and not all of it, how does anybody feel about that part of it?
It seems to me that transport may affect the wind farms more than anything else. So I wonder whether it can fall under wind farm, but includes any other transport issues. So it could still fall under the wind farm sessions, but deal with any sweeping up any other any other transport issues that arise.
Yeah. Okay. So we would stick with a wind farm hearing session. Mr. Armstrong, you've got your hand up on that.
I was going to say that there are obviously other issues in relation to access that I appreciate objectors have raised. I wondered whether it would be better under the sort of general heading, and we could just take in all the transport to access issues in that, including the wind farm matters, and that means we've got the sort of discussion about the condition in relation to the section 37 consent. We've got general considerations in relation to routes, and general access considerations, routes, heights, and everything included in the one session.
Right. Obviously, then, in a way, almost the wind farm session starts to fall away to a certain extent, because if the alternatives and the undergrounding have a direct relationship to wind farm concerns, does that wind farm argument fall into the alternatives hearing as well, where we're discussing the merits of the alternatives? Ms. Purvis?
Yes, just we have another objection in addition to access, which relates to wind protection zones. So we would still need to discuss wind farm matters, even if access is moved into the general topic.
Mr. Dunlop, you had your hand up again on that. or is it just not switched off?
I simply haven't put my hand down, my
Oh,
apologies.
okay, right, that's fine. Recap again. So we have a hearing on alternatives in the broader sense. We've got hearing on public benefit. We've got access transport matters, including the wind farm access matters. Then we would have a wind farm session on anything that wasn't about the use of the access routes. And we would pick up any other matters relating to the wind farm operations. Then we have a hearing for the Buccleuch Estates interests, just really as I've put it there, and then the Woodcock interests, and the Drumbuie, assuming that there is things remaining that are not connected to the wind farm or access. Perhaps we could get clarity over that it could be that a separate hearing on Drumbuie may fall away, and that's the uncertainty because we don't know fully the implications.
Yeah,
So,
I think,
Mr. Dunlop.
I think it's likely, ma'am, that the topics we've discussed under general and wind farm matters may mean that the matters under the Drumbuie and I'll call it the community wind power fall away. But I wonder, just to be on the safe side, whether we just keep that in case there's anything which hasn't been dealt with. The one other thing that I didn't, and maybe I just didn't note it correctly, but just so that whilst we're all on the level engagement issue, I appreciate my submission was that it should be a hearing session, for the reasons I've outlined, particularly given the recent involvement of community wind power. But I'm not sure if you dealt with that because I'm conscious.
I was really trying to deal with the things that we had agreed.
All right.
That makes sense. So these were the hearings that we were definitely having, and to work out what was remaining after that. If I then was to go to what we've agreed were definitely written submissions, which would be the human rights matters, prematurity, because it could fall away and therefore it can be picked up or dropped as a written submissions. The objector, the Woodcock interest in plot 50. The professional fees, which may or may not be a matter for the inquiry at all. And then we've actually still got, and as a fallback, the Kirkpatrick interests as written submissions as well. So that leaves us with the level of engagement as to whether or not there's a merit in having a discussion about the level of discussion, if I could put it that way, that's taken place in the run-up to the inquiry or the triggering of the notice itself, the inquiry, the compulsory purchase order notice, and then this inquiry. In a way, the written submissions does appeal because it is a very factual matter. I would have thought there either has been or there hasn't been. I don't know that if we were discussing an oral procedure, would we be in a position of discussing difference of opinion about whether or not somebody had spoken to someone or had written or hadn't replied. These should be reasonably easily recorded as a set of facts by the parties, that there either was a letter or there was a meeting or not. Mr. Dunlop, I can see your finger on a button there.
No, I suppose I'm just looking for. I think it's not just whether a letter has been written, it's what's taken place at meetings, how matters have been discussed, and the approaches at these meetings. That can't always simply be conveyed in words, in a statement, I think. So I would still maintain that there is merit in, certainly both my clients would wish the opportunity to discuss we say the lack of, it will obviously be the lack of engagement is rather than the level of engagement. I don't know whether that's supported by any other parties. I appreciate that. I think Ms. Purvis for ERG said that engagement was an issue that their clients. So it may not simply be my clients that are taking that position, but I think I would still maintain my submission that a hearing should take place in terms of the engagement issue.
Ms. Purvis, do you want to come in on that?
Yes, I confirm that my client's in a similar position to CWP in this, and that the engagement has been very recent with the acquiring authority. We don't have a strong view either way on whether hearing or written submissions would be appropriate, but we are in a similar boat, I think, in relation to CWP in this regard.
And the others, Mr. Devlin or Mr. Forrester-Smith?
Thank you, ma'am. Insofar as engagement with my own clients are concerned, my clients have not raised any particular concerns or issues directly to me. I can certainly check that point for after this pre-inquiry meeting has ended, but it's not something that has been raised as a particular issue on the part of my own clients.
Might be something that you opt out from. Mr. Forrester-Smith, do you have a wish to have a hearing or written submissions on engagement?
Unless Mr. Woodcock contradicts me, since we're not in the same room, I don't have any strong preference either way, ma'am.
But you would want to be engaged in engagement, exchange
yes,
of information or hearing?
Yes, that's my understanding from Mr. Woodcock's instructions.
We'll probably come back to Mr. Armstrong then. How would you feel if that ended up being a hearing session?
Well, Mum, as you indicated, I mean, in the main, the level of engagement is it's very much factual about whether there was a letter sent out, whether there was a meeting, and what was discussed at that meeting. That can all be set out in a written submission saying that on the 5th of April there was a meeting, X, Y, and Z were at that meeting and they discussed A, B, and C. I'm not sure what further level of information would be required for you, Ma'am, or for the Scottish ministers in relation to that point, the knowing, what was discussed at the meeting and who was present at the meeting. So I think it's one that can be dealt with by written submissions. And even if there was a dispute that a meeting took place or an issue was discussed, well, there's the opportunity for coming back with a rebuttal submission saying that somebody wasn't at that meeting or that issue was not discussed.
Yeah. Mr. Dunlop, you wanted to come back in?
Yes, just briefly. I think that puts it into kind of very black and white terms. I don't think it was a question of my client's position, oh, that person wasn't at a meeting and they'll say that person was at a meeting. It's the nature of the discussions and how they were presented. There's matters and whether or not they agree on what was discussed and the nature of what was discussed. And I don't think that can always simply be conveyed in black and white in written submissions. There's not minutes of these meetings that I'm aware of. So it will rely on and what happens where there is disagreement as to the approach that was taken. And it may be that parties feel that, as it indicated earlier, Community Wind Power have indicated to me that the information they've sought has been coming in kind of drips and drabs, and that's sometimes more easily conveyed hearing it from the actual person who's dealing with it rather than putting it into black and white. I've made my submissions on the point, and it is an area where my clients, particularly CWP, but from Bury in addition, are quite passionate about the lack of engagement, particularly at this late stage, where I indicated that there's been CWP were first advised of anything in March this year, and the first meeting it wasn't even a month ago, and they're still waiting for information from Scottish Power.
Dr. Woodcock, you've got your hand up on this matter.
Yes.
Well, I think you've muted your mic again. Sorry, you might have pressed your mic button. Dr. Woodcock, there you are.
Can you hear me now?
Yes,
Yeah.
yes.
If I give an example, I mean, we've had meetings in an attempt to engage with the acquiring authority. Those meetings have been documented by us, with the acquiring authority agreeing and undertaking to do certain actions, and then not doing them. And that's not just about recording whether a meeting took place and what it discussed. It's also about what people have done about taking forward those discussions and the things that were agreed, and that's one of our major objections.
Mm-hmm. Okay. I mean, clearly, engagement, sorry, does form a part of the inquiry matters in terms of following the guidance, that it is something that the ministers would wish to hear about as a result of the inquiry. I'm still not sure what I can gain by asking you what happened at a meeting. It's still very much about, if I'm hearing people's kind of grievances about the process as opposed to the process itself. I'm not sure how much I would gain from that. And that's what's really making me a little bit cautious about it, is that it might become a more of a complaint session about somebody's behaviour rather than constructive discussion about the success of the process. And that's what worries me about going into that particular setup. Mr. Dunlop, you want to come back in?
Just simply, if it helps allay your fears, parties are all represented professionally, so it shouldn't become a bun fight. If that's the principal concern that you have, ma'am, it should be a focused and structured dialogue of what happened or didn't happen and so forth. And you obviously have, by so doing, you'll have the benefit of those witnesses who were in attendance at the meeting. You'll be able to assess their credibility and reliability, which you can't do if it was written on paper, where there are disagreements as to what was said or what wasn't said, where there are no records of those, and we're relying on parties' essentially recollection of events.
Right. Dr. Woodcock, did you want to come in there? Dr. Woodcock? I don't know if you're speaking or not. We're not hearing you. Your microphone's on according to the computer. I think we've lost him again temporarily. Okay. Well, the purpose is to try and accommodate people's wishes as far as possible through this process. It's not about just taking one particular point of view, and it is important that people feel they've been heard through this inquiry process as a whole. So I'd probably be inclined to add engagement as a hearing matter. But I think the caveat that I would not want to set aside an awful lot of time for it in terms of the overall timetable, because I feel we could get to the nub of the concerns on that quite quickly, rather than the written submissions perhaps, or the statement of case could perhaps recite the factual evidence regarding exchanges and meetings and the level of engagement that took place. And then we would maybe just focus on particular facts coming out of that. So as long as I think we agree that it would be a very focused session on where those discussions or engagements have not been successful, then I think that might work better, I think, than using the hearing to recite everything that happened. We could certainly rely on statement of cases to give us the factual information. So that would add in another hearing session. So we would then have we'd have 6 definite hearing sessions, a 7th if Drumbuie's objections didn't all fall into the other matters that get caught up in the other sessions. We have written submissions on human rights, prematurity, if it still is relevant, Plot 50 and the Woodcock access rights, professional fees and Kirkpatrick interests. And we don't have any inquiry session where we've got witnesses, precognitions and cross-examination. Is everybody reasonably content that we settle on that and we progress forward with that? We can then look at our timetable from that. That's down on my so the time required to present the parties' cases. Now, because I wasn't sure of the scale of the number of hearings I might need to have, I've not really set aside a great deal of time to working out how long any of these hearing sessions would require. I would have hoped to perhaps deal with the site-specific matters for Buccleuch and Woodcock, perhaps in a half-day session each, but I don't know how those particular parties feel about that, to set aside a morning and an afternoon slot for each of those two areas, and again, a morning or afternoon for Drumbuie, assuming that they are fully participating in the hearing sessions that cover access and alternatives. Did those parties come back to me, Buccleuch? How would you feel about that, Mr. Devlin, if it was a half-day session to look at the issues, or is that not enough time?
I suspect, ma'am, that probably it would be enough time, but of course, it's difficult to gauge at this stage. It may be worthwhile setting aside a full day, but I wouldn't object necessarily to a half day, as long as the matters were still being fully explored if that half day was exceeded.
Yeah. Mr. Forster-Smith, how would you feel about the Woodcock concerns? Do you think that's a longer than a half day?
I would, although I'm not stealing his words, but I would adopt the position taken by Mr. Devlin in relation to this. I suspect that given the detail that Mr. Woodcock's objections might involve, I do have a concern that a half day may not be sufficient. But again, I'm in your hands as to whether or not you wish to schedule it for that, providing that there will be a full ventilation of
without seeing the full statements of case at the moment, it's quite difficult to know where the discussions will go at this stage. I'm just trying to get a handle on it. Now, the timing of the more general issues, I think the alternatives, Mr. Armstrong, you thought that would be quite a longer period than some. You think 2 days to work through all the alternatives and the evidence on alternatives?
Yes, ma'am. If it's a hearing, I think it would probably be better to put that down for two days. I would have thought in relation to the other sort of general sessions that the benefits and the transport, that could be dealt with in one day each, and the wooden farm matters also in one day.
Well, that would take us to 7 days in total. That would take us, that's a week and a half of events, in-person events. Is there any possibility to make this slightly more manageable for everybody, whether some of this could be online, making it easier to deal with a shortened day? I'm putting that out there, obviously, because it means commitments from all of you really for quite a long period of time. And if some of the potentially shorter items, or I've not even got engagement in hearing, sorry, I've got engagement. You think a half day for engagement is what I would put down for that. It's another half day. I'm wondering if some of that could be done online. So we've some hearing sessions where if we do terminate the discussions quicker, then we're not all sitting in a hotel in Sanker or something and we've got a lot of downtime. And the benefit of an online or a virtual event is that we can work around these timetabling issues a wee bit easier. So whether or not we use the in-person for the more general matters such as engagement, access, public benefits and alternatives, and maybe the wind farm potentially, and then we do the site specific, could they be done online then if we did the Buccleuch and the Woodcock and possibly Drumbuie online, or is that faces? Anybody? Oh, Mr. Armstrong.
Yeah, Ma'am, obviously standing what I said earlier that about online, if it's a sort of effectively a sort of two parties involved, and there'll obviously be a representatives there, then I think that's a more effective way of doing it, perhaps online. So in relation to site specific, if we're going to have online sessions, I'd have thought they would be the obvious ones to do online. I think all the other ones, it would be difficult to, and there'd probably be more problems than actual benefit in relation to the other sessions.
Yeah, I think so, because you have more people needing to contribute. Mr. Forster Smith, you were next on hand up.
Thank you, Ma'am. I think, as Mr. Woodcock had indicated earlier, I think he is very strongly of the view that he wishes an in-person hearing to take place rather than online. That may in part be to do with some of the technical difficulties we've experienced today, but nonetheless, those are my instructions. That his very strong preference is for an in-person hearing.
Okay, and then Mr. Devlin, you were coming in next.
Thank you, ma'am. Yeah, it was just to confirm once again on the part of my own client that I don't have any firm view one way or another as to in-person or online. Mr. Armstrong's suggestion that matters where there are only one or two parties participating being conducted by means of a Teams call seems perfectly sensible to me. And I'd happily adopt that position that he sets out.
Mr. Dunlop, if Drumbuie ended up in a hearing session, would that work as an online session as well for you?
Yes, the site-specific matters, if there was anything to be swept up, so to speak. Yes, I echo the views of my learned friend, Mr. Armstrong, as supported by Mr. Devlin, that where there are just limited, or where there's only perhaps two parties, then online can work. It's where online can go wrong is where there's a number of us. Notwithstanding this worked quite well this morning, I would add. Can I just, without wishing to rewind the clock, but in terms of written submissions, there's the issue of the ability of a CPO to interfere with the rights of a licence holder. I understood that that's just going to be dealt with in closing submissions, but I thought I should just clarify that, because I'm not sure if you identified whether that was...
I think that was going to come out of the wind farm evidence discussions, whatever happens in the wind farm session. But it could be that it overlaps with wind farm access issues. So,
well, certainly, I mean, for avoidance of doubt, it's a point that we're still insisting upon. So wherever it goes, we just wouldn't want to lose sight of it.
No, it's a good point, because it worked well when we only looked at wind farm matters as a group. But once we take some of the wind farm matters out and deal with them in the general access or alternatives discussions, then the direct relationship to the CPO and the licence holders' rights, it doesn't fit in any one of those general sessions then.
No, it seems to me that it's a point for submissions, probably following evidence, but I just wanted to make sure it hadn't slipped through any gaps.
Yeah. Ms. Purvis, did you want to come in on these discussions?
Yeah, so in relation to wind farm matters, and insofar as they are relevant to Sandy Nye Wind Farm, so that's Bullet 2 and Bullet 3 only, then we have no preference whether they're in person or online.
Right, okay, thank you. That's fine. And Mr. Armstrong, did you want to come back on those discussions?
Yes, we're obviously going to item 12 is closing submissions, but just to effectively agree with Mr. Dunlop, that I'd have thought that on the wind farm matters and indeed the access matters, I'd thought the appropriate way forward is to hear the evidence, and then there would be closing submissions. I had sort of envisaged that the closing submissions will be put in perhaps sort of a couple of weeks after the close of the hearing sessions, and that they would there'd be a sort of tapered closing submissions, obviously with the objectors going first, and then the acquiring authority coming back with a final closing submission in relation to all the matters. And so that would be where the sort of legal issues following on from the evidence in relation to impacts would be dealt with.
Well, I'm imagining if we have statements of case or hearing statements to inform these procedures, then the opportunity to introduce written evidence on the principles behind the licence matter could sit easily in the overall statements of case. Would that be correct? And then your final findings on those matters could be in the closing submissions. So the evidence regarding the relationship of that licence matter to the broader inquiry could still be present in the main statements of case. Would that be correct? I think, yeah, seems to be reasonable agreement. So it looks like we might need a fair amount of time to get through the business. By my reckoning, even if we can push if we can put the wind farm inquiry, the non-access and alternatives wind farm matters, if they're going into the hearing sessions, then any remaining wind farm matters, that could possibly be an online session, potentially, I think. And that might make things a little bit easier. We will need to spread this out, obviously, over 2 weeks now. So I'm just trying to say, and it's obviously important not to lose momentum. But again, I want to try to use time. If we are down in the Kirkconnell Sankers area, we need to use our time as productively as possible, and that's what I'm conscious of. It is possible, I think, that we could do alternatives, public benefits, access and engagement matters in a continuous set of hearing sessions over a full week. So that would be 2 days for alternatives, 1 day for public benefits, 1 day for access, and half a day for engagement. And we could use the other half day as a sort of overrun space within the week. But that would mean starting down in the area and finding a venue, which we've not done anything about yet, for a full 5 days. And then the second week, pick up the online sessions for Buccleuch, Woodcock and Drumbury and the wind farm. Does that start to work as a sort of potential timetable spaced out over 2 weeks, but where we only try as best we can to spend 1 week at most in the Sankers area, make it a wee bit easier to manage our own time and those of our witnesses and experts. So that takes me to an inquiry place. So does anybody have any suggestions? Has anybody looked at that from within the participants, either the acquiring authority? Mr. Armstrong?
Yes, ma'am. There's been a degree of investigation of possible venues in the area and also their availability. And this perhaps can be shared with the parties. That I've got a sort of spreadsheet here with availability of various venues, but the one that's one of the closest ones, the Miners Memorial Hall, which is in Kirkconnell. It is available throughout all of the dates that you, ma'am, have suggested. So that's the Miners Memorial Hall in Kirkconnell is available throughout that period. The Sanker Town Hall, there appears to be an issue on Mondays and Tuesdays. It's booked up on Mondays and Tuesdays, but otherwise it's available Wednesdays, Thursdays and Fridays throughout that period. If we were to go further afield to the Hetland Hall Hotel in Dumfries, I gather that it is available throughout that period. And also the Holiday Inn Dumfries in Brighton, just outside Dumfries, that is available throughout that period. So there is a fair degree of availability, and a number of venues that we've looked at.
Obviously, from our point of view in DPA, we always need to vet them for our own requirements to do with public access and our own sort of standards for things. Mr. Dunlop, did you have a view on that?
Hopefully it's not the last thing that my learned friend Mr. Armstrong and I agree on, but it does appear that I've literally got some of the same venues. So the Miners Hall in Kirkconnell, which I understand is near a train station. We'd also identified Sanker Town Hall. We hadn't checked availability. The acquiring authorities helpfully done that. The other one, on which I've appeared in before for an inquiry, is New Cumnock Town Hall. And again, there's a train station in New Cumnock. I can't speak to bus links. And another potential venue, I suppose, is a hotel I've stayed in during inquiries, is a Dumfries Arms in Cumnock, which certainly does weddings, so it has a large kind of function suite. And again, I think Cumnock's got a train station.
Okay, so we've got some potentials. I've taken a note of that, so we can start looking. We would have to look at, obviously, we have to arrange the inquiry, so we can go and start following up your original preliminary work. The potential for, I wondered if the parties who are looking in person, would somewhere like Dumfries, which has benefits in that there'll be a good supply of accommodation for those of us who have to stay for 5 days, less so once you're up in Sanker Kirkconnell, that's more limited. The Dumfries venues suit in terms of their locality and proximity to the venue, because it's about, I don't know, 15, 20 miles away down to Dumfries from Sanker. Is everybody happy that the inquiry would move down to Dumfries? Is that close enough for it to function as an in-person event? We're getting lots of nods, so nobody's worried about it. So if we ended up in Dumfries because it gave us the better flexibility for those of us who'll have to stay, whereas Kirkconnell, it might be that we all end up having to go to Kirkconnell Memorial Hall. Lovely though that I'm sure that is, we're all probably going to have to drive there from somewhere else because the hotel availability for everybody will be much more limited. So there's, so we'll have a look at that. So that's quite helpful. And then if we look at the timetable, then that takes us on to item 10. And that is Annex B. So if we were sticking with the week beginning 9th of September, and we're dispensing with any need for outline statement of case, it would mean that any preliminary statement case or hearing statement would need to be available by at least 4 weeks ahead, which is the date I've put in, which is the 5th of August. That takes us through, which I said in an email that was circulated, it takes us through the kind of holiday period. And it's really just giving you 1 month now to put that in place. And we still have about a week to come and go over the agreeing the note of the meeting that I'm going to issue as soon as I can this week. But that is the earliest we could do it to get to the 9th, because we have to, the rules require us to allow 4 weeks for the main statement of case, which I would say could either be or could function as a hearing statement as well, if necessary, depending on individual cases. It might be that it's an overarching statement of case and then separate hearing statements for the topics. Maybe we can have a discussion on that in a minute. The core document list has to come in, whether it's done by hearing or inquiry. We'll still need the core documents to come in at roughly the same time. We would dispense with recognitions and summaries, and I would have to issue all the hearing agendas by mid-August. So that would just give me 10 days or so to prepare the hearing agendas on the basis of those statements of case. So it's very, very tight. There's not a lot of room for people going on holiday, and there's not a lot of room for things to slip if there is any problems with procedures arising from that. I had put in an accompanied site inspection. We'll discuss that in a minute, but I had put it in for the week before just so that it didn't use up inquiry time, because it wouldn't necessarily involve everybody that has to be at the inquiry, does not need to all be at the site visit. I think we could deal with just sort of parties' representatives. And I don't mind that coming down the week before and doing that. That's not going to be a huge issue. So the main thing is, do the parties think they could honour that original timetable and get to Dumfries or Sanquhar or Kirkconnell by the 9th of September with all the statements of cases in place, or the hearing statements, and all your documents ready by the very beginning of August? So, Mr. Dunlop, you're looking to come in.
Yes, just simply to say that, and I appreciate I'm one of the least important people around the table. I'm not available. But more importantly, my client, Mr. Walker, isn't available that week. So that week of the 9th September causes us difficulties, I'm afraid. We have availability during the extended period, which has been identified, I think, in an email last week from...
Yeah, it moves into October.
Yes, it moved into October. October would be, I have to say that I think, irrespective of availability issues, I think achieving the deadlines over the summer period, where things are going to be required in almost really just about a month, where we're going into the school summer holidays, is probably quite ambitious. But
yeah, well, I was aware of that, so that's why, in a way, that I created the timetable only to show you how tight it is if you actually follow the rules to their kind of pare down the periods to the bare minimum that the rules allow. It gets quite tight even to get to September, which seems quite far away just now, but actually in terms of the turnaround of documents. So Mr. Dunlop's not available, and don't diminish your importance in the process. Mr. Armstrong, do your team have issues if we moved into October?
Certainly the September date would work for all of our team. The October, there is an issue with the planning witness, who is only available on the week of beginning the 23rd of October and the week beginning the 28th of October. I suppose the planning witness would be only required for the general sessions, but he is available the week beginning the 23rd of October and the week beginning the 28th of October, but otherwise, and also the following week beginning the 1st of November, but otherwise it's not available. And the landscape witness is not available between the 14th and 18th October and 21st to 29th October. Otherwise, all the acquiring authorities witnesses can make themselves available for the dates you've suggested in September and October.
What role would the landscape architect play in this? Is that in the general sessions, or?
Well,
not
it would be
sure how much the landscape will play a role in this.
It would be in relation to the impact, in particular, of undergrounding, and if there was a suggestion,
right. So it's the discussion of the alternatives.
Yes.
So we definitely need them potentially for the 2-day session on alternatives. Do you have a preference for order? Because obviously if we do have some online sessions, we could work around, if we were to take the online sessions, say a week earlier, would that be helpful, or is it easier to deal with the bigger stuff first and then then it makes the focus sessions on the site specific matters, we'll know what we've already covered in the other matters. Is it easier if we do that in that order so that the site specific stuff just comes later because we'll know how much we've picked up in the other sessions? Is that still the most logical way to do it?
I thought there was considerable merit in the way that you've set it out in your Annex A in the order with the general sessions, and also in my experience that's sometimes reduces it reduces sort of repetition and going over matters, and I think it also focuses the important issues in these sessions. So I would certainly have a strong preference for having the general sessions first and then the site specific thereafter.
Right. So, so if we were to go for so you said the week beginning the 21st of October, or you said week beginning? Oh no, the planning witness can do the 23rd.
The planning witness can do the planning witness can do the week beginning the 23rd of October. The week begins on
the week begins on the 21st. That was why I was just checking. So the Monday is the 21st, and then the following Monday is the 28th.
He is available on the 23rd, 24th, 25th, 26th October.
26th is a Saturday, so don't come.
He's available from the 23rd onwards
until the 31st. So he could do right. Okay. So obviously I don't want to put it off any longer than I need to. If we were to start on the 21st and we try to manage the general matters, 21st, 22nd, we pick up the one that the planning person, you can maybe confirm which sessions the planning person would have to be involved in. If we can get all that done 21st to 25th October, and then the online matters on the 28th or 29th or any time the following week, really, we could schedule the online ones for the week beginning the 28th to the 1st of November. Is that going to work if we can work out when the planning person needs to be involved? Ms. Purvis, did you have an availability issue or query?
Yes, it's the Law Society of Scotland's annual conference, the week commencing the 28th of October. It's morning sessions, Monday, Tuesday, Wednesday, and it's all day Thursday. And I appreciate we might not be able to avoid that week completely, but if we could, for anything that Sand and Irwin Farms legal team are required for, avoid the 31st of October, which is the full day of the conference, and we could maybe slot in and out of the other days.
Dear. I wasn't thinking I would have to fit in the Law Society of Scotland into this discussion. 31st, no. But you, Ms. Purvis, I'm assuming you're available then to slot into the general sessions from the 21st to the 25th.
Yes, that week's absolutely fine. Thank you.
Is anybody, Mr. Dunlop?
Yeah, unfortunately, I'm not actually available the week of the beginning the 28th. I'm available, but I'm not available the week beginning the 21st. It's a case that may go off, but I just can't make any guarantees at this stage. It's in the court session, so I couldn't just walk away from it, unfortunately.
Right. Okay. Anybody else got any kind of non-negotiable timetabling issues?
The the week beginning the 28th would certainly work for all our witnesses. The landscape witness would have to be after the 29th, but I think that could work into that time scale of using the week beginning 28th, and we could just have the alternative session towards the end of the week, or after the 29th.
Yeah.
So that would work for all our witnesses, and I think that obviously would then tie in with Mr. Dunlop's availability.
Yeah, we lose some of Miss Purvis's team, unfortunately, through some of those dates, though.
I think if Sand and I Wind Farm can avoid the Thursday the 31st, then we can make ourselves available for all the other days that week.
Right, okay, yeah. So its chances are the online sessions would then be the week beginning the 4th of November. If you
Sorry to interrupt, but I'm instructed by Kirstdale, Christy Kelshaw, the legal counsel of Community Wind Powers, out the country until the 1st of November, from the 24th. Sorry, from the 23rd. Appreciate we're making we're causing all the difficulties here.
Right. And we can't come right forward to the 7th of October for other reasons, which would be...
Okay. I could do the 7th of October. I wonder if I'm just going to go into my WhatsApp, hopefully, and we can do the 7th as well. So the 7th of October would seem to be an option.
And that would be, so 7th of October. Mr. Armstrong, does that give you a serious problem?
Well, I was going to say this: the 4th of November week would also work for all our witnesses. The 7th of October does cause a problem for our planning witness.
Planning.
Yeah. The week of the 4th of November works, and as I say, the week of the 28th October works. So, I mean, perhaps there could be.
And we could get Mr. Dunlop for the week beginning the 28th, can't we?
And the 4th November works for us as well.
All right, so the 28th, weeks beginning the 28th and the week beginning the 4th are reasonably feasible as long as we watch the wind farm session around the 31st.
No, sorry, I was available on the 28th. Sorry, it was my instructing agent that wasn't available.
Okay,
so,
right.
Sorry, so the 4th November is fine for all of us, or the 7th of, all of my, who I represent, and 7th of October. Sorry, I'm trying to go through the WhatsApps. Coming in fast. And the 7th of October is fine, and the 4th of November is fine. Yes.
Right, but we can't get some of the acquiring authorities witnesses at the beginning of 7th, week beginning the 7th of October, but we can get them all on the week beginning the 4th. And we don't want to do the site-specific online case hearings until after the bigger stuff. So that would put those online sessions to the week beginning the 11th of November. Do we then, Mr. Dunlop, your face says it all.
I'm in Inverness that week. Yeah, I'm obviously just going to throw the phone up in the air. Yeah, technically, I am in Inverness that week. That's.
Well, can I be a little bit cruel here and say that if all the online sessions, well, that would include the wind farm one, and you're acting for one of the wind farm people, aren't you? Because the online sessions would pick up the remaining wind farm issues that weren't about the general matters of access and alternatives.
Yeah, that's a good point, because I mean,
and Drumbury, we don't even know if we're having an online session for that, and it could be we don't worry that you're not available the 11th. Would that be possible?
Oh, absolutely. Yeah, that would.
And we try and get everything on the 4th till the 8th, where you need to overlap with the acquiring authorities team. Nobody else is holding their hands up in horror at the moment.
I am, I'm afraid.
Oh,
we have a key witness unavailability from the 1st of November to the 9th of November.
Okay. I'm getting fairly stuck here. I'm just conscious we're now way past 1 o'clock. I was hoping to get to the bottom of this. I think we can go on.
Is everybody represented by an agent? Because it might be it's the kind of things agents can get everybody's diaries and try and work out.
I was going to say, it might be that we actually just have to put all these dates together and we have to confirm the time, and the timetable all has to happen in the next day or two, where we can actually take a bit longer, and just rather than me trying to work out everything right now, I put some kind of spreadsheet together of potential dates for things, and we look at the best prospect. I can't rule out, I'm not meant to just keep delaying things for individuals' availability. You're aware of that. DPA are quite strict that, at some point you just have to get somebody else to act for you. It's not nice to say it, but sometimes that's what happens. I was pushing it back into October. I thought was better for the summer holiday period, but I was getting a wee bit nervous about November. But I'll put some kind of timetable together, or a spreadsheet together with the agenda, and we'll assume, for the purposes of, if we can assume other discussions, is that whatever dates we choose, all the hearing statements and statements of case would have to be in 4 weeks ahead of that. And I would take 4 weeks from the first day, not a rolling 4 weeks based on whatever day the actual individual session is. So we just get everything in 4 weeks ahead of any inquiry or hearing session from day one. And written submissions, well, we can work written submissions really at any time in this. So we can deal with written submissions through August and September relatively easily. They're not so impacted by summer holidays. So we can give a fairly generous timetable for written submissions to come in and to have the rebuttal period. So we could be doing that in advance of the inquiry. And the site visit, well, ideally is we do the site visit the week before the inquiry, rather than trying to go off on site during the inquiry session. So those are my kind of goals. And I have availability through October and November at the moment. It's not a problem. I do have some issues with September, just my own. 9th of September was perfect for me. The end of September was a kind of holiday period for me, which I hadn't quite booked. So I was kind of seeing how things went before I made any decisions about that. But it looks like October at the earliest, possibly stretching into November. Now, so the remaining matters, I covered everything. So there's the documents will come in. So we'll stick roughly with the timetable that's in that annex, but we'll just move the dates to suit the first date of the inquiry. So whichever sort of periods weekly run in, and I'll build into that a written submissions timetable as well. Just a quick question to the acquiring authority. I'm hoping it's just a simple yes. I was hoping you would assist in setting up an itinerary for the site inspection. You'll have seen from the agenda that you would kind of take charge of that and make sure we've got access. And by the time we come to do the site visit, we'll know more about the statements of case. So we're perhaps only going to look at key areas where the objectors are kind of pinpoint whether it's particular access routes or particular parts of their land holding that we go and visit. If we do an itinerary where we are dropping into each objector's area, perhaps it means that not everybody has to come for the whole site visit. We can maybe just drop in and out to suit. Mr. Armstrong, are you okay with taking charge of that for me?
Of the site visit, yes.
Yeah, that's fine.
That can be made available. There were a couple of things, though, if I could just come back on the,
yes, sorry, yes.
Timetable. Perhaps because we are doing a lot of hearing sessions, and to hopefully make life a little bit easier for you, in relation to the hearing statement, I wondered if it might be useful to have, after the hearing statement come in, perhaps the following week, a rebuttal statement, so as it would, narrow down, hopefully, the areas of dispute between the parties. That once parties see the hearing statements, that there isn't really a big issue on a number of points, but and the rebuttal statement can then perhaps focus where the big disagreements are. So that was just one suggestion in relation to the provisional timetable. On core documents, I was going to suggest that the acquiring authority could prepare a draft list of core documents, say by the 8th of July, or and if parties were to come back with their additions to that by, say, the 15th of July, we could get a completed list by the 22nd of July. That's always quite helpful in relation to preparing hearing statements, because then you can specifically reference to the core document number, which would make it easier rather than waiting to a later date. As far as other documents are concerned that parties are going to produce, but they would be on a sort of separate list, and it would be for them to produce them. And again, using the DPEA objective connect would seem the obvious way for documents to be placed in the public domain.
Yes, sorry.
Sorry, I was going to suggest also that at the hearing sessions, the acquiring authority would be able to make available iPads for any people, a couple of iPads available if there's people attending who are not part of the objection groups, so as they could have access to the documents. Our preference would be to have a paperless hearing sessions, if at all possible, and for everything to be online.
Yes, I would agree with you, and that's actually one of the reasons for being sure we've got the right type of venue where we can get access to internet and things. That's sometimes you have to watch the village hall approach in case we can't get any support for that. Your kind of the document was that sort of, if we could leave that as covering item 13 on the agenda, the document management, that's what I was coming to, and I'll send out in the agenda any information we've got about Objective Connect and how you engage with it. I think we've got some standard stuff on it, and that'll come out with the note of the agenda. Mr. Dunlop, you want to come back on anything there?
Oh,
put your hand up.
sorry, no, my hand's been up.
You're done. Ms. Purvis, you wanted to come in on something?
Thank you. It's item 11. It's a question for the acquiring authority whether their accompanied site visit would need to include a site visit to our Sandonau wind farm, and if so, if we could get at least a week's notice just so that we can arrange the necessary site inductions and protective equipment, etc.
It's possibly not, because obviously I think a lot of the stuff is about the way in. So as long as your protective zone doesn't involve the access routes, my instinct is that perhaps we wouldn't need to physically go into the wind farm. But that would be up to the itinerary from the acquiring authority. But if we can avoid going in unnecessarily, that's to be to aim for that. Now, is there any other business? I've got. I think we've covered things rather quickly at the end there, but I'm just conscious the closing submissions. I think I was hoping to do quite quick closing submissions when we come to it, but I think with all these hearing sessions and different things, I think Mr. Armstrong's suggestion that it would be a matter of weeks rather than days for putting the closing submissions together. We'll probably agree finally on the day, or certainly at the end of one of the bigger general sessions, but it's likely that there'll be an opportunity for the objectors to make their closing submissions first, which is the normal route, and then the acquiring authority gets extra time to put their closing submissions in, and they can respond to whatever you put forward on behalf of your clients. So that's how I'd manage it. It's likely to be a week and 2 weeks, if at all possible. But again, we need to watch people's holidays, and we'll hit all these diary commitments again. So we'll maybe just have to be fairly flexible on that. Mr. Armstrong?
It was just on the closing submission point. I know that the preference has certainly been at the last few inquiries that I've been involved with to have summaries of the actual hearings, evidence, or case within the closing submissions in a sort of set form. It would be helpful to get guidance sort of on whether you want that or not in your notes on this, so as we can start thinking about that.
Yes, I hadn't put it on the agenda primarily because this was a compulsory purchase order inquiry, and it hadn't fallen fully into the new procedures that we're using for more conventional planning application matters, where we're very much dealing with statements, with case summaries, to try and make our report writing more efficient. So I would say any case summary would be very, very helpful to be added into the closing submissions if the closing submissions themselves don't function as a case summary. What we're not doing now with report writing is regurgitating the case for and against. We're trying to really shrink that and then rely on hyperlinks to your own case in the way that you've worded it. So getting a case summary from you that reflects how you want it to be seen is how we are preparing to do that now. So we concentrate on our findings rather than summarising other people's cases for them. And that's the purpose behind it. I would love to see case summaries on this. If you're willing to do that, that's fine. I don't think my colleagues have had official case summaries for CPO inquiries at the moment, but we're doing a new batch of CPO work in this year, so I suspect that's coming. Just a quick question: are the participating parties happy that they would fit a case summary in with closing submissions at the end? Just nod if you are. It's fine. And yes, that's fine. Good. So I've got a bit of work to do just to put together the note of the meeting. Hopefully I'll get it right. It's possible I'll have missed something or I won't get it quite wrong. So we are going to circulate this. It'll be a draft note of the meeting. So we'll be able to input in the next day or two, make sure we've corrected anything I've missed out or picked up wrongly. We can deal with the dates. Hopefully we can get the dates sorted by the time we exchange views on the note of the meeting. And I suppose it just calls me to thank you very much for your time today, and apologies for going after 1 o'clock. I was really hoping we could get it done, but Mr. Dunlop's diary, I think we'll put it down to Mr. Dunlop's diary.
My apologies.
No, it's fine. So thank you very much. It's been very, very helpful today getting through everything. And I think we'll get a date. It just was becoming a little bit too difficult to do it online, and we'll sort that out hopefully by the end of the week. We should have a proper set of dates and plans, and I'll get my colleague onto finding the best venue for the amount of time that we need. Okay.
Thank you.
Thank you. Thanks very much.